expressed here today during voir dire, I do find it's appropriate to sustain the challenge by the state, so you will be excused for cause in this case. Thank you for your service in this case and for your honesty in the questioning. As I mentioned previously, if anybody insists on talking to you and you don't want to talk to them about your jury service, report that to the court. And if you do choose to talk to others, please respect the privacy and feelings of your fellow jurors and only discuss your own personal feelings. So that will conclude your service for today, and you can be excused.
So, to everybody else, based on that conversation, does anyone else have concerns about that? Okay. If anyone does, will you raise your hand right now? All right. So then my question to the rest of you, can you all commit that even if you see difficult information, difficult evidence, you will not allow it to overrun your common sense and reason in rendering a fair verdict? I agree to that. Thank you. I am going to turn the rest of my time over to Ms. Smith for a few more questions.
Go ahead, Ms. Smith.
Thank you, Judge. Good morning. One of the things that we're going to chat about briefly is some of the answers you might have had on questionnaires about some of the legal concepts that you kind of commented on. The court and only the court is the one who gives you the law in this case. And the questionnaire asks you about sort of general ideas on what you thought kind of coming into this process. But in the end, the jurors all have to agree that the law that they're given by the court is what they'll follow. Sometimes there's a lot of misinformation out there in the community about legal ideas and legal concepts, and we need to make sure that you don't have some sort of opinions, which we all bring with us into any room, that's going to make it hard for you to follow what the court says. And that's one of the things I'm going to chat with you about briefly in context of this process. Juror 695, and I think I understand your questionnaire. I want to make sure I read it correctly. You got part of the jury selection process, correct?
Yes, I was, what do you call this? The
veneer process, voir dire, yeah.
And then I was not chosen to be on the jury, but I was there all day.
Okay. Did you have to sit through this process and all the questioning?
Yes.
Okay. You understand that the instructions that the court gives in every situation, every trial, is based on the facts of that case?
Yes.
Okay. The court doesn't make it up. He pulls it from, required statutes under the law and from the law given by the legislature and the higher courts, but each one is uniquely tailored to each situation.
Yes.
Okay. Is there anything about that experience that's going to make it hard? Are you going to be doing a compare and contrast, or can you?
No, I went through it twice. I've been on jury. I've been called 4 times. I've been through it twice, and nothing happened. No comparison.
So you've been called 4 times, but you've been through this questioning process twice. Okay. Now, let me talk to you a little bit. And the court read you the instruction on sort of the burden of proof in the process in this case. And you heard about beyond a reasonable doubt, correct?
Yes.
Okay. So let me break it down just a little bit and ask you some questions about, in context of some of your prior exposure. You understand when the court is talking about the burden of proof, that relies on the prosecution only?
Yes.
Okay. And the court will give you those instructions, definitions of what each of those crimes mean.
Yes.
All
which
right.
I would need.
Yeah. Well, and that's why the court gives it to us, so that we're all, like Mr. Wood said, all operating on the same definitions, right?
Right.
And those definitions will have parts. We call them elements, but they're really just parts. They're like ingredients in a recipe, right?
Okay.
And we have to prove each one of those parts beyond a reasonable doubt.
Right.
All right. And what happens if the state proves 3, but there are 4 parts, and there's a 4th part that we fail to prove beyond a reasonable doubt? What happens?
Well, I'm not clear on that. If it's
Okay.
because you have the conspiracy and then you have the actual murder, and so is there a conspiracy and not that? Would you be convicted on that and not on that?
Well, and this is why we.
At that point, I'm going to interject a little bit. We're going to get into legal definitions and legal instruction, which is the province of the court. So I understand the answer, nothing wrong with it, but if we'd move on to more appropriate voir dire questions, please.
Yes, yes. And I'm not going to define anything. That is absolutely the court's job. Each crime, without getting into it, the court will provide those definitions for each separate crime. So the jury evaluates each thing separately. Does that make sense?
Yes.
Okay. And the state has to prove each one of those individually beyond a reasonable doubt.
Yes.
All right. If there is a part of one of those for that particular charge that you found the state did not prove beyond a reasonable doubt, could you, even if you believe the other charges, could you find someone not guilty when the state didn't prove part of a charge?
Yes.
Okay. You understand that would be the job of the juror to do that?
Right.
All right. Do you have confusion on that issue?
No.
All right. You understand in context of that if the state fails to prove its case, Ms. Vallow Daybell never has to do anything, right?
Right.
The job, and it's only the job in this case, to prove Ms. Vallow Daybell guilty.
Right.
Okay. And that she is presumed innocent unless and until the state proves beyond a reasonable doubt she's guilty of one or all or none of the charges.
Yes.
All right. Thank you. Let's turn towards Juror 1020. Good morning.
Morning.
Did I read your questionnaire correctly that you were part of the Marines?
Yes.
All right. Well, thank you for your service. It looks like it was for quite a period of time.
Only as much time as they made me be there.
Well, you were there, and we thank you. But my question is, what did you do in the military?
First and foremost, we're a rifleman. And second after that, I repaired machinery, towed artillery, tanks, minesweepers, things like that.
Okay. Did you ever serve overseas?
Yes.
Where?
Iraq.
Okay. Okay. Did you ever have to see any combat?
Yes.
Okay. So that's going to lead me to some questions specifically on that issue. Is there anything about that experience that will make it difficult for you to evaluate evidence that may include pictures of a sensitive nature?
No.
Okay. Can you put any sort of exposure you might have had to those issues sort of aside and focus on the evidence you hear before the court?
That's correct. I'll do my duty.
Okay. Thank you, sir. Juror 1219. Thank you. And forgive me, sir, I failed to write down. What do you do for a living?
I manage a company that we do suspension work on vehicles. So we also manufacture lift kits, sell them worldwide.
All right. Thank you. Now, Juror 906. I see that you are an EMT. Okay. Is that here in Ada County?
Yes.
Okay. Do you ever have any interaction with the coroner's staff?
Only
In the
on a
worst.
transfer basis
Okay.
on scene.
Okay. Did you recognize any of the names? And I didn't see that marked, and that's why I'm just double checking.
No.
Any of the names on the proposed witness list?
No.
Now you're going to hear from some, but not all, but you might hear about all of those people. Is there any of those names that even seem familiar?
No.
All right. Let me circle back on some of the potential scientific issues in this case. You've had some medical training?
Yes.
Okay. Have you heard the phrase cause of death?
Yes.
Okay. Have you ever had to be part of a coroner's inquiry?
No.
Have you ever had to testify in a case that involved a questionable death, either on a civil side or the criminal side?
No.
All right. In evaluating evidence, the court is going to give you definitions and tell you what the state has to prove, right?
Yes.
Okay. But the court is not going to tell you how the state has to prove its case. Does that make sense?
Yes.
Okay. And so he's not going to give you a list of evidence we must supply in order to consider convicting someone.
Yes.
All right. And the instructions from the court are going to be very specific that the state has to prove, the jury has to use their reason and common sense to believe that the state has proved each part of the charges. But he's not going to give you the formula that we have to follow to get there.
Yes.
Okay. Now, in cases involving homicide, death at the hands of someone else, the state has to prove that a particular person was part of and contributed to the death of a person. So it's death at the hands of others. Does that make sense?
Yes.
If the state supplied evidence that a person was killed, murdered at the hands of another, and the evidence, you believe that evidence beyond a reasonable doubt that someone was responsible for causing the death of a person, but the state couldn't give you the precise reason or way the person died, what mechanism caused their heart to stop beating or their brain to stop functioning, but you believed beyond a reasonable doubt that the person was murdered at the hands of one of the people involved, or, as a result of the conduct of one of the people involved, could you consider convicting someone of murder?
Considering what was brought forth evidence-wise, yes.
If you believe the state proved its case beyond a reasonable doubt, even though they couldn't tell you how a person died.
Yes.
Okay. Juror 695, I saw you kind of sit up, and it may be just stretching, but I want to make sure that I don't miss somebody. Thank you, sir.
Well, I'm just confused. If you don't know exactly how they died, then I would just have to listen to everything and figure it out.
Right. And that's the job of any juror. You would have to listen to all the evidence, take the instructions of the court, and decide whether the state proved beyond a reasonable doubt all of the parts of the crime to see if you believed the person was responsible for contributing or causing the death of a person.
Yes.
Okay. Even if the state couldn't tell you that even when the state could not tell you exactly how the person died, whether they were shot or stabbed or strangled, but they certainly were dead at the hands of someone else.
Okay.
Does that make sense?
Yes.
Okay. Any confusion?
No, I don't think so.
Understand. And that's where Mr. Wood's analogy on that pilot comes in. That's why he does that is, look, there are some times on cases that jurors are like, look, maybe this isn't the case for me. But in this situation, it is way too important to Ms. Vallow Daybell and to the people of the state of Idaho to have I think or I hope. It's about, and that's okay. The question is, do you think you could consider convicting somebody in a situation where the state could prove that a person was dead at the hands of another? They just can't show you exactly what caused the heart to stop functioning.
Right.
Could you do that?
Yes.
Now, I saw all of you listening attentively to that line of question, and I'm not going to, for expediency's sake, I'm not going to ask each time, does anybody have a reaction? But since I hadn't made that clarification first, everybody heard those conversations I heard was 695, correct? I see nods from the whole panel. Does anybody have a reaction or a concern to that line of questioning? Okay, I see everyone saying no, that they can follow the law and apply the law given, correct? Okay. I believe I'm done. Your Honor, let me just double check with my colleagues if I may.
Sure.
One more, Your Honor.
That's fine.
Let me pull it up. Juror 1219. There's a little bit of confusion, and it's probably my poor note taking. Did you mark that you might have a hardship?
Not really. Work was kind of a question, but I've talked to my employers, and it'd be more of a hardship for them than me. But, you know, they said that if it comes down to it, they can make it work, whatever they have to do, so.
Okay. Thank you, and thank you for checking up on that. We just wanted to make sure we didn't miss something. All right, and there's nothing about that work situation that's going to make it so that you can't give both Ms. Vallow Daybell and the people of Idaho a fair trial?
No.
Okay. Thank you, sir.
All right, at this time then we'll allow for voir dire questioning from the defense. Mr. Thomas.
Morning. I'll be brief because most of the questions have either been asked by the judge or the prosecuting attorney, so I'll try to be brief here. So I know that the prosecutor said something to the effect of given everything that you know about this case, can you set all that aside? And that's kind of hard to do because you really don't know what you don't know, right? So have any of you seen a car accident? Have you ever witnessed a car accident? Anybody? Yeah. We've all seen fender bender or something. So if somebody were to say, okay, well, set everything you saw aside, and I'm going to tell you that there was no car accident. It was just something that you saw. That'd be really hard to do, right? So we need you, and going back to something that the prosecutor said, we need to be brutally honest. If you know something, you need to say something. See something, say something. If you know something, we really need to know because we really don't want to get into a situation where we're in the middle of trial and a witness gets up on the stand and you say, oh, geez, man, I should have said something that I actually watched an interview of that person, or, gee, I know a little bit more about this and somebody's made an objection and now something's not coming in, but I know something extra, right? Does that make sense to everybody? It kind of does. So we're going to get a little bit into the media, and I don't want to get into it right now, but that's something that we're going to get into, and that's kind of one of the things I want you to keep in your mind. Like, maybe I'm not the right fit for this jury if I know something about something that, that may not, that everybody doesn't know. So that's that. Now, 1020, you're a musician? What do you play instrument, or are you a singer, or what do you do?
Country music.
Country music, right on. All right. And have you been doing that a while?
Yeah, since last 4 years.
Okay. You in a band?
No, I'm a solo musician.
Oh, okay.
Yeah.
All right. So you were also in the Marine Corps.
Yes.
Did you ever serve in Pensacola, Florida?
No.
No. Okay.
No. My father did.
Did he really?
Yeah.
All right. I knew a good friend of mine is a colonel in Pensacola. So, you indicate that you don't watch the news too much.
No.
Okay. Do you know anything about this case?
No.
Okay. All right. Thank you. 906. You indicate that you're an EMT. You've seen some pretty bad stuff. Car accidents are kind of like bread and butter for you type of thing, right?
I work at a more of a local setting at a company, so.
Okay, so maybe not so
I'm
many
like
car
Ada
accidents.
County, but yeah, not so many car accidents.
Okay.
All
All right.
Can't
They
talk
happen.
Sorry, we can't talk at the same time. It will be very difficult for the courtroom.
Right. I apologize. Is there anything you need me to repeat or? Okay. And so you work at a company?
Correct.
And so, like, what kind of stuff do you see as an EMT?
Mostly work-related injuries.
Carpal tunnel?
Unfortunately, some of that, but I mean, actual injuries.
Oh, okay.
Acute and sometimes chronic, like you.
Gotcha. Okay. All right. You said something. You know what? I'm gonna wait, and I'm gonna have another question for you, but I'm gonna wait until there's a specific time that we're gonna talk about the media exposure. So I'm gonna wait on that. Okay. So I'm done with him. Thank you. Let's see. 1219. You indicated that you had some exposure on online news outlets. Do you watch podcasts at all?
No.
No? Okay. Do you watch YouTube at all?
If it's a directional video that I need or, instructional video, something like that, then I'll watch YouTube.
So mostly work-related type stuff?
Yeah, for the most part.
Okay. All right. And you make lift kits, is that right?
Correct.
For for trucks?
Trucks, yep.
Okay. All right, cool. That's all that I have for him. Thank you. 1167, you're the dentist, and we talked a little bit, and I feel like maybe I was a little bit sharp, and I was kind of picking on you a little bit, but I wasn't. I'm actually trying to help you out if you needed to get out. I have a brother-in-law who's a dentist, and I know that it's hard work. I mean, there's a lot of hands-on work type going on. So, is there anything that I said about being able to set things aside and being able to set what you know about this case aside and be able to focus in on the case? Is that a problem for you?
No, I don't think it is.
Okay. All right. Okay. Thank you. And 1159, I haven't heard from you at all, actually. So tell me a little bit about yourself. What is it that you do?
I'm a software engineering manager.
Okay. And looks like you went to the U of I. Did you live here most of your life? Are you a Boise
I've lived
resident?
in Boise for 30 years, but
Okay.
grew up in California.
Oh, okay. Where in California?
North Coast, Crescent City, far North Coast.
Okay. How far is that from San Fran? I'm familiar with San Francisco.
Over 300 miles, although I also lived in the Bay Area for 4 years.
Okay. Okay. So it says here that you've been called several times to jury duty, but never been put on a jury.
That's, one time I was selected for a jury, but before the trial started, the defendant changed their plea, so it never went to trial.
Oh, okay. Okay. And how did you feel about not having to, like getting in the hot seat and then being relieved of it? Was that a real relief, or was it kind of like you kind of wanted to sit on it to figure out what was going on?
Well, it would have been interesting, but it was something of a relief. It was going to be a difficult trial.
Okay. And I have a couple of questions for you as well, but they're mostly for the media section. So, all right, Your Honor, I think that's all I have. I would ask the court to do individual voir dire at this point.
Very well. Thank you, Mr. Thomas. All right, counsel, the court, upon reviewing the questionnaires, I think everybody needs to be talked to with the exception of Juror 1020. I just didn't see anything in the questionnaire that I thought merited individual voir dire. If you'd take a moment and review that questionnaire and let me know if there were any issues you thought needed to be discussed, we can include that. If not, we'll talk to the other jurors.
The defense doesn't have any issue with 1020.
Neither does the state.
Okay, so the parties will pass 1020 for cause. Is that correct from the state,
Yes.
from the defense?
Yes, Your Honor.
All right, so Juror 1020, you'll just be waiting while we talk to the other jurors, and then we will have Juror 695 remain seated, and everyone else can be taken to the jury room while we do individual voir dire. Why don't we all rise for the jury and stretch our legs a little bit? All right, thank you. Please be seated. All right, Juror 695, you've had some responses in your questionnaire that indicate some knowledge of this case, and we need to question you about that. As I've said to many people in this case, there's nothing wrong with following the news and reading about things that interest you or keeping up on current events. The question we have here is whether or not it would be appropriate for you to serve as a juror given what you know about this case already. So to start off, I have a couple of questions of my own, and then I'll let the attorneys conduct their questioning. Before you reported for your questionnaire last week in this case and up till now, were you aware of what this defendant was charged with, including here or anywhere else, before the court told you what the charges were?
Yes.
And what specifically did you know?
I knew that she was charged with possibly murdering her children.
Okay. And did you know any more detail about the charges themselves?
No.
Okay. In the past, have you reviewed or seen any television programs that focused on this case, like a Dateline special or a 48 Hours or a made-for-TV movie or a Netflix documentary or anything like that?
I don't watch television.
Okay. Run across or view anything devoted to this case on the internet, like on a YouTube channel or anything like that?
No, the only source I would have would be the newspaper, the Idaho Statesman.
Okay, you read the Statesman. Okay. That concludes the questions the court would have for this witness, or I'm sorry, this juror 695. Mr. Wood, if you'd like to conduct individual voir dire, you can.
Juror 695. Oh, let me grab my computer real quick. You've stated you don't watch the news.
No, we don't have cable. We don't have TV in our house.
Okay. Do you have any internet streaming channels like Netflix?
We have Netflix and and I do watch. So on the internet, I would watch or listen to Boise State Radio, and NPR, and then, like I say, the Idaho Statesman, which is both hard copy, and then the online version.
Okay. So it's fair to say you consume a fair amount of news.
Yes.
Okay. And I'm sorry, I wasn't quite sure. Did you say you do have Netflix or you don't have Netflix?
We do have Netflix. We do have some streaming.
Okay. Do you recall if you watched a Netflix special dealing with Miss Vallow Daybell?
No.
Okay, you didn't. Going through your questionnaire, and just to start, there's nothing wrong with watching the news.
Right.
There's nothing wrong with knowing things, right? We're here today to determine if this is the best case for specific jurors. In your questionnaire, it would indicate you know a fair amount about this case. Would you agree with me that you know a fair amount?
I know what it's about, yes.
Okay. And on your questionnaire, it asks if any of your possible exposure to reporting dramatized depictions or other publicity has caused you to form an opinion about the defendant. Do you recall how you answered that?
No, I don't. I don't think I have an opinion about the defendant. And I can tell you where my one concern is, that I first became aware of so the kids are missing, and I first became aware of the possible reason they were when Lori Vallow and Chad Daybell were in Hawaii. And so my main, I guess, question there is, if your child is missing, are you going to go to Hawaii?
Sure.
Unless you know something.
Okay. And let's talk about that, because in your response, if it's okay if I tell you what you wrote, you did mark the box, yes, you'd formed an opinion, and said, I think she knew or knows what happened and concealed that knowledge. I think she was involved to some extent in Tylee and JJ's deaths. And again, there is nothing wrong with watching the news, forming opinions. We all do that. Can you see how, to the state, who's trying to make sure there's a fair and impartial jury and trial, and to the defendant who wants a fair and impartial trial, how that statement could be concerning?
Yes, I do. And I can say on the flip side, I have absolutely no idea what happened. I mean, I stopped paying attention because everything was so sensationalized, and I can't stand that stuff. So I can honestly say I have no clue if she was part of it or not.
Okay.
But I do think she knew what happened because she went to Hawaii.
Okay. All right. And again, nothing wrong with reading the news, nothing wrong with having opinions. But, Your Honor, based on that, the state would move for Juror 695 to be excused for at least implied bias.
All right, any response from the defense on the challenge?
The defense agrees, Your Honor.
Okay, the court's reviewed the questionnaire as well and agrees that there's been shown a bias has been formed that may not be able to be set aside in this case based on pretrial publicity and exposure to the story. So juror number 695, we very much appreciate your candor in answering your questionnaire and the questions today. Thank you for your time and your jury service, and you can be excused. You're welcome. Let's have juror 906 brought in next. That's fine, Mr. Archibald. All right, juror 906 has returned for individual voir dire. The court's reviewed your questionnaire, and it appears you've had some exposure to media coverage in this case prior to being called for jury duty. The questions we want to get into at this time are whether or not your prior knowledge of the case may serve to potentially disqualify you from serving on this case. So I'll start off with a few questions of my own for juror 906. Let me ask you first, before you reported for your jury service in this case last week to get the questionnaire, did you know what the defendant had been charged with here or anywhere else?
Not formally, no. The formal charges, no.
Okay. Have you watched any news programs that focused on the case, such as Dateline or 2020, or any documentaries or made-for-TV movies or anything like that?
No, just normal KTVB news coverage that a couple years ago, 2020, when it was an original topic, right? When it was fresh.
Okay. Those are the questions the court had on individual voir dire. If the state would like to inquire, you may.
Good morning.
Morning.
We noticed on your questionnaire you made some comments about that the news is not always accurate, right?
Yes.
Okay. And this really is about fairness. Both sides in this case deserve to try and be judged on the evidence and the burdens on the state that's only presented in this courtroom, right?
Yes.
Okay. And so one of the reasons it's so important that we question you on these things is we need to make sure that anything you might have seen on a news channel isn't going to be in the back of your head while you're listening to the evidence on this case or while you're assessing whether the state proved its case beyond a reasonable doubt. Do you understand that?
Yes.
Okay. Is there anything about the news segments you saw that you think, hey, it's made me, form an opinion on her guilt or her, on her guilt?
I wouldn't say so, no.
Okay. You understand that the jurors in this case have to commit to anything they might have heard, assume one, it's not true, and two, put it out of their head. Can you do that?
Yes.
All right. Now, looking at your specific answers, let me pull it up real quick. Of course, my computer went to sleep right that second. You said specifically, no, I think it's only fair to judge based on evidence as news is not evidence.
Correct.
Do you still believe that statement?
Yes.
Okay. Anything that's occurred in here that's changed your mind about that?
No.
All right. And then you also made a statement that you would say her involvement is suspicious. Have you heard any actual evidence?
No.
Okay. If the state fails to prove each part of the crimes, if we fail to prove any part of the crime or crimes given to you, what must your verdict be?
Not guilty.
Okay. And is there anything about what you've seen or heard that's going to cause you to hesitate to do your job and find her not guilty if we don't prove it?
No.
Okay, thank you. Nothing further.
All right, thank you, Ms. Smith. The defense may conduct individual voir dire of this juror.
Morning, Juror 906. How are you doing?
Good. How are you?
Good. So you indicated that you've watched some KTVB, some things there, and you indicate that you know that the kids were found in Rexburg. Is that right?
Yes.
And what else did you hear on the news? What else do you know about the case?
Chad Daybell is involved, not directly with this trial, but
Okay.
His wife. I don't really have any concrete answers to that question. I don't know a lot, so.
Okay. When you indicated that there's a question on the questionnaire that says, have you formed any personal opinions whatsoever based on information from any source of Lori Noreen Vallow, a.k.a. Lori Noreen Daybell's guilt or innocence of anything? And at first it looks like you hit no, and then you scratched it out, and then you hit yes, and then it says, if yes, briefly explain, and it says, I would say that her involvement is suspicious. And so what's suspicious about it?
I think for that answer, right, and I'm only vaguely remembering the KTVB random bits I saw early 2020s, but the lack of having an answer of like where your kids are, right, that's just like suspicious, right? I think that's why we're here, both sides, right, to argue whether or not there's any guilt involved, but I mean, it's suspicious, right?
So what did you hear about? She didn't know where her kids were. What did you hear about that?
Just the news coverage, media asking, right? I think they were in some part of Hawaii, and not being able to answer, like, where the kids were, right? And that's really where I was getting at is, like, that's just a suspicious thing.
Okay.
Guardianship, right? Guardianship-wise, right?
Okay.
But, I don't know. That's just weird.
Okay. And so you didn't follow up on any of that? You didn't hear anything else on any of the... You don't follow on social media or anything?
No.
Do you have social media?
I do.
You have Facebook?
I do. And you see, like, an article pop up, but I don't click into them, especially since we've been told not to, right? So.
Right. But a lot of that stuff happened before you came to court, right?
Correct.
Okay.
But I didn't necessarily open them.
Right,
I mean,
right. Were you curious at all before you were called to jury duty?
I can't say I thought much of it other than another story, right? So I
Okay.
don't really get into the news much.
Okay. When you were called to jury duty, did you talk to anybody about having jury duty?
Just like my employer and my family that I'm maybe on this case, right? Well, on a case that'll last, right?
Okay. And so you talked to your family about being on a case that might last 8 weeks, and did somebody say, yeah, that's probably the Lori Vallow case?
I think there's a lot of assumptions, right? I mean,
And that's what we're trying to get at. What were the assumptions that were made? What do you know about what was said? What was said to you?
can you elaborate? I don't know. What's your question?
Well, when you were told that you were having jury duty and you told your employer, did they say anything about, oh, that's probably the Lori Vallow case, or that this is what happened in that case, or did they?
Of course, yeah. I mean,
So what were the kind of some of the things that they said?
well, just like, oh, is that the Lori Vallow case? And of course, I can't confirm or deny, right? But I mean, I think it's probably and I don't know this, but maybe the only case that has such a large sampling of jurors, right?
Right.
So I think the assumption is fairly made by most people,
Yeah.
right?
And was there any discussion about what the Lori Vallow case was about?
No.
No? Not with your family?
No.
Okay. Your Honor, based on his response on page 16, paragraph F, lines 19 through 23, where he indicates that he had formed an opinion and that he would say that her involvement was suspicious, I'd move for cause to dismiss this juror.
Let me ask a follow-up question or two of juror number 906. When you recall footage you saw about Hawaii, do you recall seeing any footage of the defendant herself or her saying or stating anything in the footage you viewed?
I don't recall if anything was said, but footage of the media seeing him walking and attempting to ask questions, right, is what I'm recalling.
All right. Does the state have a response to the challenge?
Yes, I think given this juror's answers to simply base answers here in court and his answers on the questionnaire where he specifically says, I think it's only fair to judge based on evidence. The news is not evidence. Coupled with his attitude and demeanor here before the court, there's nothing to merit any strike for cause. The box that is checked that defense counsel noted didn't provide context, didn't provide an instruction or anything that would suggest that would give him what his duties were as a juror, and it did not give him an opportunity to say whether or not he could follow his duties as a juror in the courtroom. He was given that information by the court, and on questioning from basically all three parties, he indicated he could do his duty.
All right, I've considered the challenge in this case and looking at the standard also set out in Idaho Code 19-2019, subsection 2, and that's the sound discretion of the trier of fact as to whether there's an inference based on these questions that this juror would or would not act with entire impartiality. It is concerning that there was exposure to publicity in the case. I've heard that explanation on question 10F, and that was concerning as well, but having considered the follow-up questioning as it relates to this juror's commitment to following the instructions of the case, I don't find that this would rise to the level requiring a challenge for cause to be sustained, so I'll overrule the challenge as to juror 906, and I believe unless there's any further voir dire in light of that, we'll conclude our individual voir dire. Does the defense have any further voir dire? Okay, so juror 906, you'll return to the jury room and we'll bring out our next juror for questioning. That will be juror 1159. All right, juror 1159 has returned for individual voir dire. The court's reviewed the questionnaire responses, and this juror presents some knowledge of the case from prior news coverage or other sources, and so those are the topics we want to discuss with you at this time individually. I'll ask you a couple questions of my own, and then the attorneys will be allowed for further questioning. So before you reported for your jury service last week when you got your questionnaire, did you know what the defendant had been charged with here or anywhere else?
Not in any detail, but yeah, I knew there was a charge, likely murder charge.
Okay, and can you just explain as specifically as you can what you knew about charges that had been filed?
I wouldn't say I knew anything about the charges being filed other than I knew it was a murder case and charges had been filed. So that's really the extent of my knowledge.
Okay. Have you ever viewed any news programs or documentaries or movies that focused on this case, like a 2020 or a Dateline or a Netflix documentary or anything like that?
No.
All right, that concludes the court's questions for Juror 1159. If the state has an inquiry, you can do that at this time, Ms. Smith.
Had to check the clock. Good morning. I just want to ask you some follow-up questions on your questionnaire. Do you have Netflix?
Yes.
Okay. Did you see anything on Netflix about Ms. Vallow Daybell or anything about this case?
No.
Okay. Prior to me saying that, had you known there was anything on Netflix?
No, I was not aware of any Netflix
Okay.
related elements.
Okay. I did notice on your questionnaire there's a couple of things that you mentioned knowing about. Have you heard, you said very little. I recall seeing pictures, I think, a young boy and a young girl who I thought were JJ and Tylee, and when they were described as missing and assumed deceased. Where did you get that information or that fact you stated?
I think probably local TV news.
Okay. And did you ever hear about when the kids' remains were found?
Not that I recall.
Okay. Online news sources. Do you put that in your questionnaire that you said I saw, maybe have seen some things on online news sources? Any national news or only local online news?
I don't recall seeing it on national news, although I suspect I probably have in passing, but nothing that I watched, intently.
Nothing on like Dateline or 2020 or any of those type shows?
No, I would have been, national NBC, CBS news type.
Okay. Now, I just need to ask, you heard the line of questions about the state's burden of proof, right?
Correct.
And it really is about a person who can be fair to both Ms. Vallow Daybell and the state of Idaho. You agree with me?
Yes.
Is there anything about what you think you remember or what you saw that's going to make it hard for you to be fair and impartial going into the case for Mrs. Vallow Daybell?
No.
What about the people of the state of Idaho?
No.
Okay. You understand that the parties in this case have the right to be judged and have the case evaluated based on only what is allowed by the court here.
Yes.
Is there anything about what you saw that you're going to be thinking about as you're sitting there watching the witnesses testify or seeing evidence come in?
No.
Can you assure us that you can put that out of your mind?
Yes, I can.
Okay. Now, may I ask a quick, and I apologize, Your Honor, I missed this before, just a quick hardship question? I can do it later, or I can just, it's not.
Yeah,
long.
let's ask the hardship issue now.
Okay. There's just a little bit of stuff written on your questionnaire where you said you could fulfill at least some of my obligations in the late evening or afternoon, but you later said it might be employment status is protected. Do you remember that?
Yes.
Okay. Have you had a chance to check with your employer about if you were to get called for service for an extended period of time?
I have.
Okay. And what was their answer?
Basically, we would figure out how to make it work.
Okay. Is there anything about that that's going to be sitting in the back of your mind affecting your ability to concentrate and assess witness credibility or judge the evidence?
I don't believe so.
Okay. The reason we ask that, we want to make sure there are no distractions, that you can focus and, be 100% present.
Yes, I understand.
Okay. Any concerns?
No.
Thank you, sir.
All right, thank you, Ms. Smith.
Thank you, Judge.
Thomas, if you'd like to conduct individual voir dire of this jury, you may.
Juror 1159, you indicate that you recall seeing pictures of a young boy and a young girl who you thought were JJ and Tylee. Do you recall what you saw? What were these pictures? What do they look like?
They were like school pictures, maybe. I mean, just individual headshots.
Kind of like a mugshot or a headshot?
Yep.
Okay, headshot's probably better. Okay. And that was just on a like a news feed, or was it a nightly news type thing, or what? Do you remember?
Either nightly news or online news.
Okay. Do you ever get on YouTube
Yes.
and kind of go down some rabbit holes on that? Did anything on the Vallow case ever come up?
No, I haven't seen anything on this case on YouTube.
No? Okay. And I think the prosecution asked you about Netflix and whether or not you saw the Netflix special. There was also, it was trending for a while. Do you watch Netflix on the daily or just every now and then, or how does that work?
Infrequently.
Infrequently? Okay. So it's possible that you didn't see the trailer or anything about this case.
I don't recall seeing it.
Okay. All right. You didn't see anything on Facebook or LinkedIn, anything like that?
Not that I recall, no.
Okay. You a TikTok guy?
No.
Yeah, me neither. All right. Thank you.
All right, thank you, Mr. Thomas. As for Juror 1159, then, does the state pass this juror for cause?
Yes, Your Honor.
Does the defense pass them for cause? Okay, thank you. Juror 1159, if you'll just return to the jury room with the bailiff, we will have Juror 1167 come in next. Okay, juror number 1167's been returned for individual voir dire. You've indicated some knowledge of this case through viewing news reports or pretrial media exposure, so we want to discuss that specific topic with you at this time outside the presence of your fellow jurors. Just a few questions the court will have for you, and then I'll let counsel inquire. First, before you reported for your jury service last week to fill out the questionnaire, were you aware of what charges, if any charges, had been filed against the defendant here or anywhere else?
No.
Okay. Have you ever watched any news programs that focused on this case, in particular, like a documentary, a 2020 special, a Dateline special, or made-for-TV movie, or anything like that?
No. Really the only exposure I had, I think I wrote on my questionnaire, probably 3-4 nights a week, my wife and I, just while we're getting ready for bed, the local news is on. And most of the time with that, even, I have 2 children that we're trying to get down to bed as well, so it's kind of real hit and miss. But that is probably my exposure to this.
All right, that concludes the court's questioning. At this time, if the state would like to inquire as to Juror 1167, you may.
Juror 1167, thank you. So you, just so to make sure I understand, you said you at night have the news on as you're going to bed and getting your kids ready for bed?
Correct. Yes.
Okay. I believe you stated in your questionnaire, I don't want to misquote you, you were familiar with the defendant's name.
Yes.
Do you have Netflix?
Yes, we do.
Do you recall if you've ever watched anything about this defendant on Netflix?
I know you're referring to the documentary that is on Netflix, and I have not watched that.
Okay. Do you know if you saw a trailer for it or?
Not that I can recall.
Okay. Do you recall any specific stories you might have seen on the nightly news as you were watching it or getting your kids down for bed about the defendant?
I would say the part, the only part of it that kind of comes to mind with any clarity was when the defendant was in Hawaii.
Okay. All right. And did anything about that, on your questionnaire, you state that none of the news reporting has led you to form an opinion about the defendant's guilt?
No. I haven't formed an opinion. Also on the questionnaire, my wife is an attorney, and so she was a clerk for a federal judge, and so I've kind of been exposed to the court system, so a lot of times, like my philosophy with regards to the judicial system, she's always preached to me, hey, it takes fair and impartial people to make the system work. And so, I don't think any of these things, I understand what needs to take place to form an impartial jury.
Okay.
And to try the case.
And so you've answered this on your questionnaire, but just to clarify for the court, is it still your position that any of the news you've seen, that none of it has caused you to form an opinion about the defendant's guilt?
No, it has not.
And you understand that she comes into court today with a presumption of innocence?
I definitely do.
And it is only the state's job to prove the case against her?
Yes.
She doesn't have to do anything?
Correct.
Okay. And nothing you've seen in the media would cause you to change your mind about that, correct?
Correct.
Okay. The state has no further questions.
All right. Thank you, Mr. Wood. Mr. Thomas?
So really the only question I have is about the Netflix series. You indicated when Mr. Wood asked you if you had Netflix, and then you kind of jumped in and said, well, I think you're talking about the Netflix documentary. Mm-hmm. So how did you hear about the Netflix documentary?
Through friends and, that had seen the documentary.
Oh, and they've talked to you about it?
Yes, they have. Back then, it was one of those. Right. It was one of those conversations. Hey, this
was trending number one. I'm sorry, Judge. I didn't mean to talk over him.
No, I was just saying. Yeah, it was a typical conversation. I'm always having conversations. What good series is anybody watching on streaming? And it brought up in conversation.
Yeah, and what was the conversation about? What was said about the Netflix series?
Oh man, you're asking me to recall specifics. It's hard to recall specifics. Probably something in the light of this was interesting.
Nothing good, right, about my client?
I don't remember anybody bashing your client or anything in specifics of that nature.
Okay. All right. Do you recall the title of the series?
I do not.
Okay. Your Honor, in light of what he may recall later on when we have actual witnesses testifying about his conversations with friends and family about this Netflix series, I would move for cause on implied bias.
All right. What's the state's response?
Thank you, Your Honor. I think I almost said the witness, the potential juror, has made it very abundantly clear that he has not formed any opinions. He understands this process. He understands the presumption of innocence and the burden on the state, and that he has no prior knowledge that would prejudice him against the defendant. And so we would object to that motion.
All right. The court's reviewed the challenge for bias on this juror after questioning and reviewing the questionnaire. The court finds it would be speculative to indicate that there was any bias shown based on the candid responses of the juror, so the challenge is overruled, and I understand the state passes juror 1167 for cause. Is that correct?
Yes.
All right, and the court will overrule the challenge, so juror 1167 will return with follow-up instructions in a moment. You'll return to the jury room, and we've got one more potential juror to discuss individual voir dire with, and then I'll give you further instructions. Thank you. You're fine. All right, juror 1219 has returned for individual voir dire. We wanted to ask you some additional questions to follow up on your questionnaire responses. You've indicated some knowledge of this case through watching news about the case before you reported as a juror. I'll have a few questions to just start off with you. Before you came in for the questionnaire last week, did you know what this defendant was charged with either here or anywhere else?
I guess I would say I knew that they had been charged with something as far as the kids, murder or whatever.
Okay. Did you know any more particular details about that?
No.
Okay. Have you ever watched anything like a Dateline or a 2020 special or a special news program that focused on this case, or a documentary or movie or anything like that?
No.
Okay. That would conclude the questions I have for this juror. If the state would like to conduct their individual voir dire, you may.
Good morning. I'm rushing us. Thank you. I do have a couple quick questions about some of the answers you had on your questionnaire. What was the source of your knowledge or what you believe the charges were? Where did you get that idea?
I'd seen a few headlines here and there, never really read the stories, and then just hearsay people talking about it.
Seen some headlines. Like where did you see the headlines?
Probably it would have been on like local news, I guess.
Okay. When you say local, like your local TV, your local paper?
It would have been probably local online, yeah.
Okay. Do you have Facebook?
No.
Okay. Do you use, probably not, but I gotta ask, do you have Instagram or Twitter or
No.
and on YouTube, do you have a user account with YouTube?
No.
Okay. So if you've seen the headlines and you knew about some of the charges, did you ever read any of those stories?
Not really. I honestly try to avoid the news. I just found that it, causes me unnecessary anxiety, whatever you want to call it, throughout the day. So that's part of the reason I got rid of all my social media a couple years ago.
Gotcha. Gotcha. A lot of people have done that. My question is, you said you kind of heard the hearsay or the, people talking. What people do you remember hearing talking?
I mean, I guess a couple guys at work, they just said something along the lines of, they, had found the kids, and then, they had made some arrests from it. So there was not really anything in detail about it. But
How long ago did you have were these people talking about this?
it would have been, I don't know, 6 months ago, a while ago.
Okay. Did any of those people express opinions?
Not that I can remember.
Okay.
I think it was just more of a, blanket statement about it. So,
All right. What about once you got your jury summons? Did the people at work kind of talk about it again?
no.
Okay. What about once you had to talk to the people at your employment about being here? Did it come up?
No, I mean, I told them there was a chance that, I could be on jury duty for a couple months, and they never mentioned anything specifically about what case it was or anything like that. But
Okay. Is there anything about that experience or that sort of headlines, the conversations that you're going to hold against Ms. Vallow Daybell?
no.
You know that both sides have to come into a case with sort of a clean slate, right?
Yes.
Okay. And one of the reasons we ask these questions is to help make sure that jurors in your spot aren't sitting there thinking about something they saw outside that neither party can do anything about.
Yeah.
All right. Any concerns about your ability to kind of put any of the comments from colleagues or anything you might have seen on the local stations out of your head?
No, I have no concerns with that.
Okay. Thank you. The state will pass.
All right. Thanks, Ms. Smith. Mr. Thomas, voir dire?
Briefly, Judge. When I'm a little bit concerned about things that you had heard from other people talking about things that they had seen or heard. And so I just kind of want to delve a little bit into that. Did you hear anything about a gentleman by the name of Alex Cox?
No.
No? You don't know who he is?
No idea.
Okay. Did you hear anything about Ms. Vallow's, any other issues that Ms. Vallow may have in other states?
Nope.
No? Okay. Your Honor, I have no further questions.
Okay, thank you. So, as I understand, then the state would pass for cause juror 1219. Is that correct?
Yes, Your Honor.
Does the defense pass this juror for cause?
Yes, Your Honor.
Okay, juror 1219. Why don't you remain seated there for a moment?
Okay.
We will bring back in jurors. Should be 906, 1020, 1159, 1167. All right, gentlemen of the jury, you've been passed for cause at this time, or any challenges have been overruled by the court, allowing you to go to the peremptory challenge phase of this case, which will take place in all likelihood later this week. So you'll be required to report back again. The jury commissioner is going to contact you, and at this point we'll give you a card that's the business contact information for the jury commissioner, who will give you your further instructions to report. Just please be on standby. That could happen fairly soon. Very importantly, while you are waiting to come back, please continue to follow the previous admonishments you've been given several times, to not in any way go look this case up, watch about the case, learn about the case. If you see anything reported about the case, please turn that off or disregard it, so that you can continue to be somebody that would be impartial enough to serve on this jury in the case, which you've been determined to be up to this point. While waiting also, if anybody approaches or questions you or follows you or wants to talk to you about your jury service, please report that to the court, because you're not allowed to engage in those discussions at this point. So with that in mind, that will conclude the individual voir dire for this group of jurors. Does the state have anything further to say before we let them be excused?
No, Your Honor.
All right, anything further from the defense? Okay, I'll rise for the jurors, and then we will discuss scheduling. We've got a second group to come today that's scheduled. Yeah. Please be seated. All right, counsel, thank you for your efficiency today. Our 11 o'clock group is here. We do need to take a break. I'd like to get started with that group, and I'll just discuss briefly with administration, thinking that we can perhaps have a lunch break while we're doing this second group and not go through the whole thing without them or us having the lunch break, so we can get into the afternoon if necessary also. Let me discuss whether or not that's a feasible plan, or whether we should take a break now and go straight through, and then we'll let you know. Just give me a few minutes to discuss that, and then I'd prefer to get started with them and then break perhaps while we're doing the voir dire. Okay, we can start the simulcast, and we're ready to go on the record.
Thank you, Judge. It's live.
Okay. We will go on the record again on CR 22-21-1624, State versus Lori Vallow. The parties are all present, as is the defendant. We're ready to start with our second group of jurors for individual voir dire. The court's received agreed to challenges, which we'll put on the record once the jurors are brought in. So at this time, the court would ask the bailiffs to bring in the next group, please. Bring the. Okay, thank you.
All right, please. Panel's all present, counted for you.
All right, thank you. Please be seated. All right, this is case CR 2221-1624, State of Idaho versus Lori Vallow. We are going through voir dire of jurors in the case at this time. A group of 15 jurors has been brought in. The court has reviewed the acknowledgement signed by each of the 15, indicating they've complied with the court's prior admonishments while they were since the time of filling out the questionnaires. We'll do voir dire of this group then, and I'd like to welcome you all back and thank you for reporting back as requested to do so by the court for this process. The first matter we'll take up is that the questionnaires have now been reviewed by both the court and counsel. After going through those questionnaires, the parties have raised certain challenges, and the court's prepared to make a ruling on those by also indicating there's been stipulations from both sides. So, ladies and gentlemen of the jury, if you return, I'm about to read off the numbers of certain jurors that have been challenged. If you are excused, please don't feel offended or feel that there's something you did wrong. We're simply trying to make sure we have the most impartial jury we can for this case, and also jurors that are able to fully serve and give their entire dedication to this case during the long time frame it will take to try it. So for certain of you, the challenge has been raised, and I'll indicate who that is at this point on the record with each one. After I've concluded reading the group that's been excused, then you'll be free to leave, and I'll give you a final instruction before you go. And so starting off with the first challenge was juror number 1319. The parties reviewed the questionnaire and believed that the juror indicated a hardship requiring them to be excused from the case. Does the state object to a hardship excusal for 1319?
No, Your Honor.
Does the defense agree?
Yes, Your Honor.
All right, juror 1319 will be excused based on a hardship. Juror 1324, that juror also, based on the review of the questionnaire responses as it relates to the time frame of the trial, indicated a hardship. The state and defense have both raised a challenge on that cause, and the court would find good ground as well. Does the state agree that juror 1324 can be excused for hardship?
Yes, Your Honor.
Does the defense agree?
We agree.
All right, thank you, counsel. Juror number 1326. Upon review of the questionnaire for this juror, the parties determined that a challenge should be raised for the reason of bias, and the court, upon review of the questionnaire, also confirms that. Should juror is the challenge on 1326 from the state for bias?
Yes, Your Honor.
All right, does the defense agree with the challenge?
We do.
Very well. Juror 1326, the court will affirm has been excused also on the basis of bias. Juror number 1377. Court's also reviewed the questionnaire there. Does the state challenge juror 1377 on the grounds of bias?
Yes, Your Honor. Yes, Your Honor.
Defense agree with the challenge?
We do.
All right, the court agrees as well that based on some pretrial exposure to the case of by this juror, news coverage of the case, they'll be excused. Juror number 155. Excuse me, 1554. A challenge was raised based on bias also for this particular juror. Is that the state's challenge?
Yes, Your Honor.
Does the defense agree with the challenge?
We do.
Very well. The court has reviewed that questionnaire also and finds grounds for excusal of this juror based on bias. Juror number 1604. Parties also, upon review of the questionnaire, indicated to the court a challenge would be raised based on bias. Does the state raise that challenge?
Yes, Your Honor.
And does the defense agree that this juror should be excused for bias?
We agree.
The court will find that also for an excusal for cause for juror 1604. And then juror 1621. Could I have a brief sidebar with counsel on this one?
Holmes. I'll ask. But just for the sidebar, I need it. So, yeah, I'll ask him if would you hit the button when they get back up there. Yeah, the one in front of the church. Thank you. Judge, we're just resuming the simulcast one moment.
Okay.
It's live. Thank you, Judge.
Okay, thank you. The court reviewed a potential challenge on 1621, and that juror will remain for further voir dire at this time. So going back through the list then of jurors I mentioned, 1319, 1324, 1326, 1377, 1554, and 1604. The court will excuse you from your jury service. The court very much and the parties appreciate the time you've committed to come in and fill out your questionnaires and return today. Please don't take any offense on the fact that you've been challenged. It has nothing to do with your honesty or integrity. It's simply the process we go through to try to obtain the most impartial jury we can to try this case. So with the appreciation of the court, you can be excused, and I will just advise you, if you wish to talk about your jury service with anyone, you can do that, but please respect the feelings and privacy of your fellow jurors and only talk about your own perceptions. If somebody persists in talking to you and you don't want to talk to them, please report that to the court and we'll take that issue up with whoever's doing that. So that will conclude your service for today if I read your number off, and you can be excused. All right, the first thing I'll discuss then with the remaining jurors is our schedule here. I know you've already been here some time. We've been going since the morning and we'll want a lunch break. We've accommodated to get you something to eat here at the courthouse if you do want to have a lunch break. We're going to get started and go for some time now, and probably in about 20 minutes or so, around 12:30, we'll be taking a break during this process, so you'll be required to stay here during the break, but again, we'll have lunch brought in for you if you're hungry. And then we'll continue on with that. Otherwise, the process will just take too long to get through given the timing. So that's the schedule we'll be following. All right, at this time then, I'll thank you again for returning. I'll reintroduce myself and the court staff again. I'm Stephen W. Boyce, the District Judge of Fremont County. My court clerk is Shannon Holstein for this case, and she will be keeping minutes of these proceedings and administering oaths to you. We have the bailiffs here who are assisting me with maintaining the courtroom order and working with the jury. Our court reporter here is taking the stenographic record of the proceedings, and my staff attorney, who sits over at the table by the window, occasionally will assist me with legal issues that arise. Each one of you is qualified to serve as a juror of this court, and each of you filled out your questionnaire, as I mentioned, that's now been reviewed by the parties in the court. The first thing we need to do in this trial is to select a total of 18 jurors, which will be 12 jurors and 6 alternates. At this time, in order to make sure we have the record clear of who's here, I'll request that our court clerk take a roll call of you as jurors. So she will call you out by your red card number. Once you hear your number, if you'll just indicate audibly here, then we will complete the roll call. So Madam Clerk, would you do the roll call at this time?
Juror 1265. Here. Juror 1381. Juror 1462. Here. Juror 1465. Juror 1535. Juror 1560. Juror 1621. Juror 1628. And Juror 1631.
Okay, thank you. This time the court will then introduce the parties and the case again to assist you in understanding this process. The case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. The state is represented at this trial by Lindsay Blake, who's the prosecutor for Fremont County, by Rob Wood, the prosecutor for Madison County, and by Special Appointed Prosecutor Rachel Smith. The defendant, Lori Vallow, is represented by her attorney, Jim Archibald, and her attorney, John Thomas. Thank you, counsel. This case is a criminal matter, which means the defendant has been charged by the state of Idaho with a violation of the law. When you were here last week to complete your questionnaires, the court read a summary of the charges that are contained in the indictment. I'll read you a more brief version of that indictment at this time, as well, the list of the charges included in the indictment. So with regard to the defendant, the state of Idaho has alleged that Lori Vallow Daybell committed the crimes of count 1, conspiracy to commit first-degree murder and grand theft by deception, count 2, first-degree murder, count 3, conspiracy to commit first-degree murder and grand theft by deception, count 4, first-degree murder, count 5, conspiracy to commit first-degree murder, and count 7, grand theft. The defendant has pled not guilty to all the charges. Please remember that is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If, after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next discuss your duty as jurors. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During the course of this trial, including this jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including any use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I will ask that the court clerk administer the oath to the jury panel. So, ladies and gentlemen of the jury, would you please stand and raise your right hand?
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God?
Okay, thank you. Please be seated. At this time, I'll inquire of the parties. Will the state stipulate that these jurors have been properly called, impaneled, and seated?
Yes, Your Honor.
Will the defense also stipulate that the jurors have been properly called, impaneled, and seated? Thank you, counsel. In this part of the jury selection, you will be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, I would ask that you just raise that red card you have with your juror number. We'll also instruct the attorneys to only refer to the jurors by using the red card. I'll also indicate that for your privacy, there are cameras that in the courtroom for the simulcast that's occurring in 2 other locations, but you are not on those cameras. So we'll use the red card numbers for anonymity of the jurors. In order to keep a clear record, when you're asked questions, if it's yes or no, please answer verbally yes or no instead of shaking your head or nodding your head or saying uh-huh or uh-uh. Also, please try to avoid talking at the same time as any attorney questioning you or the court so that the record remains clear that way also. In this case, there's been a lot of pretrial media coverage and publicity. We want to make sure that you don't discuss any facts you know about the case in front of your fellow jurors, because there will be a time to discuss that with you individually regarding any knowledge you may have about this case. Also, if there are any other matters of a sensitive personal nature that shouldn't be heard by the public, then we can also arrange to discuss those matters in private with you, and counsel is instructed to notify the court if we're going to question jurors on any of those issues. I'll also instruct the attorneys for both parties to avoid repeating any questions that have already been asked, and the attorneys do have the right, however, to direct follow-up questions to jurors regarding any response to previous questions. In terms of the juror challenges, as you've seen here today, several jurors have already been challenged. Again, each side does have challenges called for cause, by which I mean that the side can ask a juror be excused for some specific reason. In addition, each side has a certain number of peremptory challenges, by which I mean each side can challenge a juror and ask that he or she be excused without giving a reason for the dismissal. If you're excused by either side, please do not feel offended or feel your honesty or integrity is being questioned, because it is not. This time then, the court will commence with the beginning of my questions for you. And then I'll let counsel have their voir dire after I've completed mine. So the first question I'll ask for all of you as a group is, in regards to the questionnaires that you completed last week, are the answers provided in your questionnaire still true and accurate today to the best of your knowledge? Yes or no? Okay, thank you. All the jurors answered yes. Let's next talk about the time commitment that would be required for this case. If you're required to serve as a juror in this case, it would be for a period of approximately 8 weeks. Would that time frame required to do that create a serious hardship upon you or your family or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case? So if you want to discuss the time required to serve, please raise your red card. Okay. Did you want to discuss the issue? Okay. Juror number 1381.
I work for the banking system, so I have obligations that way, and then I have prior travel arrangements next week, so I don't know if that will conflict or not.
All right, let me ask some more questions about your employment. Have you discussed with your employer the possibility that you may be required to serve here?
Yes.
And did they what did they indicate would be their policy?
They're okay. It's just they got to find somebody to cover for me, I guess.
Okay.
So, but they were okay with it though. Just.
And would it cause a financial hardship to you, or would you continue to be able to be compensated if you served?
I think I should be able to be still compensated.
Okay, and the attorneys will have some follow-up questions, I'm sure. Can you explain a little more about the travel arrangements you have when that is?
My son, he's a senior in University of Montana. He runs track, so we already had a prior commitment to go down to Long Beach to watch him in his track.
And when would that be?
Next Wednesday through Saturday or Sunday, I guess.
Were you going to fly to Long Beach or drive there?
We're flying.
Do you know if your airline tickets are refundable or not?
I'm not sure. My wife does all that stuff, so.
All right. Let me have some follow-up voir dire, if I may, from the state first and then the defense.
Okay.
The state doesn't have any follow-up questions right now.
All right. Does the defense?
Your Honor, the defense does not have any objection to excusing this juror for cause based on his hardship.
What's the state's position on a for-cause excusal for hardship for this juror?
Your Honor, I think with the request to move him for cause, we would have a follow-up question.
Go ahead.
So, sounds like you have a trip planned to watch your son run track. Not sure if the tickets are refundable or not. If they are refundable, is there another opportunity that you would have to go watch your son run track, or is this a single event?
Could we get the microphone to him so we'll get that response on the record? Thank you.
It's not a single event. He's in track season, but it's to going to California. It's his first time going. He's a senior, and this is his last year of running track.
Okay, Your Honor, given that response, the state doesn't have an objection to him being released based on that hardship.
Okay. The court's reviewed that, and based on the challenge of the defense, joined in now by the state, I do find that Juror 1381 has presented good cause to be excused for purposes of hardship, so thank you for reporting back and for your commitment. The previous admonishment I gave about if anyone wants to talk to you or you talk to them would apply as well, and with that, you can be excused. You're welcome. All right, when I initially asked also, I didn't see any other people raise their hand on the time commitment. Okay, we do have another juror that would like to discuss that, and that is Juror 1560. Would you explain how being required to serve may create a hardship for you?
Yeah, so I have a full-time job. I'm actually the only employee at the moment for them. I have discussed it with them, and it's not a problem at the moment. I also am a single mother, so my daughter does not go to daycare. My mom actually watches her, so it will be doable, but it will be difficult for 8 weeks.
All right, any voir dire by state on that issue?
Just to clarify with you, I know you've indicated it would be a hardship, especially if it was for the full 8 weeks, but you also indicated it's doable. Is this something that you could manage between work and childcare?
Yes, it will be difficult, but yes, I could. I have discussed it with my mom, and we could do it.
Would anything about that cause you concerns with your ability to come in and pay attention to the evidence being presented in light of the schedule given by the court?
No.
I don't have any further questions.
All right, thank you. From the defense?
Ma'am, you indicated that you had talked to your employer and you're the only employee at the time, at right now, is that right?
Yes, that's correct.
And so what are they, they're just going to shut down the shop for 8 weeks?
I'm not sure what he's going to do. He actually is in the process of trying to hire someone right now.
Okay.
I'm not sure. He hasn't really gave details on that.
So you being the only employee, are you on salary?
I am.
Okay, and they're willing to pay you your salary for 8 weeks?
I haven't discussed that with him yet.
Okay.
I can discuss that with him, though, but I'm not sure what he would say about that.
I'll ask a
please.
follow-up question.
That would help
on
me.
that. As the sole employee, is there some possibility that your absence could affect the business going forward? In other words, would you potentially not have a job to come back to if you were gone for 8 weeks?
There is a possibility. I didn't get much details from him. I'm sorry.
Okay. And the child you have at home is 2 years old, is that correct?
That's correct.
All right. Well, the court is going to find, based on your responses there and some potential peril for your employment if this occurred, even though your employer apparently has been very kind in allowing you to serve, being the sole employee, I think creates a hardship for you that may occur if you had to serve the entire time of this case in addition to caring for your child. So the court will find that Juror 1560 meets the requirements to be excused for a hardship reasons. So thank you so much for your time in reporting today. And as I've mentioned to those other jurors that were excused, if you choose to talk to people, please be respectful of your fellow jurors. And if somebody wants to talk to you and you don't want to talk to them, just report that to the court. All right, with that, you can be excused. On the issue then of the time frame required to serve, did anyone else have a concern? All right. Let me next go through questions about, well, I'll indicate on the knowledge of the case section, we'll come back to that individually with you about any information you have about this case that you learned before you came to court. I'll next ask you some questions about the subject matter of this case. Would the subject matter of this case, which involves charges of murder, conspiracy, and theft, would that make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? All right, all the jurors said no. There's next questions I need to ask you, which might seem obvious based on your questionnaire responses, but in order to determine if there's any implied bias under Idaho law, I ask these questions of every juror. Are any of you related by blood or marriage to the defendant, and I'm referring to the defendant Lori Vallow, or do you know her from any business or social relationship? Okay, everyone said no. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you or any of the attorneys? Okay. Everyone said no to that. Are any of you a party in any civil litigation against the defendant? Everyone said no. Have any of you ever brought a criminal complaint against the defendant or been accused of a crime by any of the prosecutors in this case? Okay, everyone said no. I'll next have the counsel introduce themselves and who works in your offices in order to go through the next set of questions. So starting with the state, if you'd please introduce yourself and also the other prosecutors and attorneys in their offices, then we'll ask the defense.
So I am Lindsay Blake with the Fremont County Prosecuting Attorney's Office. In my office are also Tanya Rawlings, Rocky Wixom, and Blake Hall. We also have Rob Wood here, who is the Madison County Prosecutor. Within his office are Mackenzie Cole, Spencer Rammel, Adam Garvin, and Troy Evans. Then we also have Rachel Smith here, who has been deputized in both Fremont and Madison County as a deputy prosecutor in both offices.
All right, thank you, Ms. Blake. Mr. Thomas?
Thank you. My name is John Thomas. The attorneys working in my office are Jordan Crane, Tyler Salveson, Alex Sosa, Paul Butikofer, Brad Rigby, Justin Bowles, Tim French, and Jason Gustavus. And we work in Eastern Idaho.
All right, thank you. And Mr. Archibald?
I'm a sole practitioner on my own.
Okay. Having heard the names of all those attorneys, then I'll next ask this question. Are any of you as jurors related by blood or marriage to any of the lawyers, or do you know any of them from any professional, business, or social relationship? All right. Do any of you have any kind of an attorney-client relationship with any of those lawyers mentioned or the lawyers here today? Everyone said no to those questions. Let me next ask if you've ever previously been on a jury. Have any of you previously served on a jury? Okay, we have no's except for a yes, juror 1462. All right, let me ask you a few questions about that. When you previously served on a jury, was that a case that actually went through a trial? Okay, and were you part of the group of jurors that determined the case?
Yes, I was.
When was that?
It was the early 2000s. I'm not sure of the exact year.
And where was the court where that happened?
Los Angeles County.
Was it a criminal or a civil case?
Criminal, I believe, was drunk driver.
Okay. And was there anything that happened when you were previously serving as a juror that you think would in any way impact or affect your ability to be fair and impartial in this case?
I don't think so.
Okay, thank you for your response to that. Anyone else previously been on a jury? All right, everyone else has said no. I'll next ask some general questions. Have any of you ever formed or expressed an unqualified opinion that the defendant, Ms. Vallow Daybell, is guilty or not guilty of the offense charged? Everyone said no. Do any of you have any bias or prejudice either for or against the defendant? All right, everyone said no. As it relates to witnesses, the questionnaire listed the witnesses that may be called to testify in this case, and you were instructed to identify any witnesses that you might know. Are your answers in the questionnaire still true and accurate to the best of your knowledge? Okay. Is there anything, having thought over this since you filled the questionnaires out, is there anything in your questionnaires you think should be changed at this time? Okay, everyone said no. Are any of you unwilling to follow my instructions to you, the jury, as to the law you must apply in determining the case? Everyone said no. Do any of you have a religious or moral position that would make it impossible to sit in judgment of another or to render a fair and impartial verdict? Everyone said no. Are there any of you that if you were selected as a juror in this case would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? All right, everyone said no there. And finally, do any of you have any other reason why you cannot give this case your undivided attention and render a fair and impartial verdict? Okay, everyone said no there. That would conclude for now the court's voir dire. The attorneys will now have an opportunity to do that. Looking at the clock, I think this will be our time to take a lunch recess. I'm thinking, counsel, if we could, let's try to resume again at in about 45 minutes, so 20 after. And we'll resume then with attorney voir dire of this group of jurors. As I mentioned, if you would like lunch, I believe it's provided or probably on the way if it's not there yet. So thanks for your patience in going through the lunch break with us, and we will be in recess for now.
All right, please.
Thank you. Please be seated.
Judge, would you like me to resume the simulcast?
Yeah, you can go ahead and start that.
Thank you. Judge, the simulcast is going.
All right, thank you. We can have the jurors brought back in, please. Thank you. Please be seated. Okay, we are back on the record. Case CR 2221-1624, State versus Lori Vallow. We had a lunch recess. We're resuming voir dire of today's second group of jurors. The court has reviewed the seating chart and finds that the remaining jurors are all properly seated. And here, the court had just concluded its own voir dire examination. I'll note counsel's all present and the defendant is present as well. At this time then, the court will pass the voir dire to the state to conduct any questioning you have at this time. Ms. Blake.
Thank you, ladies and gentlemen. I know this has been a long process. You were here last week and you're here again today. And we do appreciate you coming back as we're trying to get a jury ultimately selected in this case. To answer a question that may be on some of your minds, because it's not often that you hear about two elected prosecutors being involved in the same case. So in case anyone's wondering that, we do have both Madison County and Fremont County here. As you heard, we both have fairly small offices. And as you may recall from when the judge read the indictment in this matter, parts of these crimes are alleged to have occurred in both Fremont and Madison County. So for those reasons, the offices have joined together in this prosecution. So in case anyone was wondering, thinking that was a little bit odd, I just wanted to let everyone know that. The judge went over this, but I just want to remind you, as we're going through the questioning process with you, so both the state and the defense, if at any, and the judge and the court for that matter, if at any point you feel uncomfortable with a question asked, you feel like you would rather talk about it outside of the purview of others, please let us know. There may be topics that we touch on that are somewhat uncomfortable. There's a reason that we're doing it, and we'll talk about that, but please don't hesitate to raise your hand. And the reason for that is we do want to make sure that we have all the information that may be necessary. If there's something that you feel the parties may know that could affect your ability or you have concerns about serving, that's what we want to hear. And so please don't hesitate to do that. And that leads into part of what we're going to ask you to do today. If I use the term brutal honesty, I want you to think about what that means to you. And Juror 1631, I'm going to ask you if you hear the term brutal honesty, what comes to mind or what would that mean to you?
To me, it means telling the truth regardless of consequences.
And Juror 1265, I'll ask you the same question. If I use the term brutal honesty, what does that mean to you?
Just be truthful no matter what's at stake or hurting someone's feelings. Just be honest.
And I think those were both very consistent answers, and that's what I want you to think about, is sometimes we may say things, we may believe things, and we may try to spare others' feelings. We may worry about how it's going to make us appear. But throughout this process, we are going to ask you all to be brutally honest. Can everyone here commit to be brutally honest? Does anyone have any concerns? Looks like everyone indicated that they can be brutally honest. And the reason we talk about that as well is I want to give you an analogy here. Have all of you flown on a plane before? So when you get on the plane, the pilot comes over the intercom usually and tells you an approximate arrival time, may tell you, it might be a bumpy ride, but that they'll get you there and you should land at about whatever time it may be. And you can sit back and enjoy the flight. If instead of that, the pilot got on and said, hey, I'm going to do my best to land the plane, we might get there at this time, would anyone here feel comfortable staying on that plane? And if you were given two choices, you have one pilot that tells you, I can land this plane, no problem, and one that says, I'm going to do my best. Which flight are you going to get on? The first one with the pilot that can land it? Would we all agree that's the flight we'd take? So that comes into play here because essentially you are all going to be like the pilot. You are going to be asked to follow instructions given by the court and only the court. So at times we may hear of a law or we may hear an element of a crime that we disagree with. We might think this seems silly or this isn't how it should be. And we need to make sure that everyone can commit, not say, I think I can. So similar to, I think I can land the plane, not, I think I can follow the instruction. We want to make sure that everyone can commit, yes, I can follow the instruction. And the reason for that is that both parties here deserve a fair trial. Both Ms. Vallow Daybell and the state of Idaho that represents the citizens both deserve the right to a fair trial. And in order to ensure that, we need to make sure that all jurors can commit to following the instructions as given by the court. Does anyone have concerns with their ability to follow the instructions given by the court, even if you may disagree with it? Looks like everyone answered no, that they would not have a problem doing that. Does anyone here believe that everything we see on the internet or the news is 100% accurate? I think everyone answered no. And Juror 1621. Why would you not believe everything on the internet is 100% accurate?
It could be political, like leaning more to the left or leaning more to the right. It could be someone wanting to tell misinformation for their own agenda.
All right, thank you. So different people may have different agendas or different viewpoints. Would you agree with that?
Yes.
And so that information may not line up with what you would consider to be accurate.
I like to do my own research and form my own opinion.
Okay. So you don't just accept what the media puts out as fact. You like to go and research it yourself and form your own opinion?
Yes.
Okay. And I'll ask Juror 1465. And why do you not believe everything on the internet or in the news?
If you listen the next day, it's different. So many untruths are being told.
Okay, thank you. And we're going to touch more on publicity later, and I think the judge let you know that'll be done separate and individual voir dire. With the next thing I want to talk about a little bit is the nature of this case. And again, the court touched on this. Just want to follow up a little bit. This is a case in which you are going to hear about the murders of 2 children and a mother of 5. Knowing that you are going to hear information and evidence regarding those things, does that cause anyone concerns about their ability to sit on a jury in this matter? Some of the evidence may not be the easiest to view in this case, and you were asked on the questionnaire about the potential to review some disturbing images. Knowing that there may be some evidence that's difficult to look at and that you may have a reaction to, which it's normal to have a reaction, does anyone have concerns that their reaction would be such that it would overcome their reason and common sense? And Juror 1535. I believe you have some children, is that correct?
I do.
And if you were to see some photos depicting children, would that, and maybe some graphic photos, would that cause you concern?
Yes, it would cause me concern.
Do you believe that you would have a reaction to that?
Probably internally, yeah. It would make me feel uneasy.
Okay. With that, though, do you believe that if you were shown that and you were also presented other evidence, do you believe that you would be able to set aside any reaction you may have and give all of the evidence, every piece, the weight that it's due?
I would be able to do that, yes.
Do you feel like it would affect your ability to be fair and impartial simply because you may have a reaction?
No.
Okay, thank you. And I'm going to ask Juror 1462. I believe you also have some children that are older now.
Yes.
Same question for you. Do you feel that it would cause you concern to the point that it would overcome your common sense and reason if you were to be shown some photos of children?
It would certainly cause me a lot of concern. I don't think it would overcome my common sense.
And do you believe that you could still listen to all the evidence presented and give all of the evidence the weight you think it's due and be fair and impartial?
I could certainly try.
And we talked about the pilot analogy. So do you believe that your reaction would be such that it would absolutely overcome your common sense and reason?
If what we were presented was extremely graphic, it could.
Ms. Blake, on this topic, I think it needs to be asked if you look at her answer to question 13 on page 9.
Yes.
Thank you.
And I think in your questionnaire and what the judge is just referencing is you had indicated that blood makes you nauseous and that it may make you likely to faint.
Yes, it does. I can't watch people draw blood or anything like that.
So, and when you say you can't watch people draw blood, that would be if you were there in person actually watching it.
Correct.
Have you ever watched a movie or seen photos in which blood is shown?
I try to avoid them. Otherwise, I pretty much hide my eyes.
If there have been times that you've caught glimpses in a movie or through photos, has it actually caused you to faint?
Not since I was a child.
So as an adult, you've been able to view those images. While upsetting, it hasn't caused you to faint.
Yes.
Do you believe if you were to be shown images that weren't something that you really wanted to see, would you still be able to view them?
Yeah, I'd be uncomfortable, but I could view them.
And I think it's normal to be uncomfortable. So then the question would be, would that uncomfortableness make it so that you could not view other evidence and fairly weigh all the evidence presented?
No, I think I could do that.
Thank you. And I'll ask Juror 1628. I believe you also have some children.
Yes, ma'am.
And do you feel that viewing images that may be unpleasant to view involving children would cause such a reaction in you that it would overcome your common sense and reason?
I think it would be distressing, but I think I'm a pretty level-headed person overall.
So do you think that you could view evidence of that nature and give it the fair weight due along with other evidence presented in reaching a fair and impartial verdict?
Yes, ma'am.
Thank you. And the reason we go over some of this stuff is, like I said, and I just want to reiterate, all parties are entitled to a fair and impartial trial, and that goes for both Ms. Vallow Daybell and the state of Idaho. So that's why we go through these questions with you, just to make sure that we are selecting a jury that can be fair and impartial. So with that, I'm going to turn things over to Ms. Smith with the state for some further questions. Thank you all for your time.
Good afternoon. Thanks. I'm going to spend just a couple minutes following up on some things in some questionnaires involving some making sure that there isn't a misunderstanding of or some ideas that are floating out there that as to the law, and making sure we can all follow the court's instructions, because the law, as Ms. Blake has said and the court has said, is given to you by the court. I just wanted to follow up just a little bit. Let me start with Juror 1628. Ma'am, I noticed from your questionnaire that both your mother and your stepfather were parole officers?
Retired parole officers.
Okay. And I understand from looking at that questionnaire that they were parole officers for a several years?
Yes, ma'am.
Okay.
Yes, ma'am.
Okay, thanks. And ma'am, did you ever discuss their employment with them?
Just maybe overall, never any specific people, just general impressions and things that they would experience.
Okay. Now, sometimes people who have experience with the system and or their families, they hear stories or they hear about things out there. Let me just ask a quick question. You understand in this case, as the court has read to you, that the state of Idaho, the people of the state of Idaho, bear the burden of proof, correct?
Yes, ma'am.
Okay. Only the people of the state of Idaho, the prosecutors, have any responsibilities to prove anything.
Yes, ma'am.
Okay. And those responsibilities extend to every part of every charge. Does that make sense?
Yes.
The court will provide you the instructions, and they will have definitions in them, kind of parts. And there'll be multiple parts, and the people of the state of Idaho have to prove each one of those parts beyond a reasonable doubt.
Yes, ma'am.
Okay? You understand that Ms. Vallow Daybell doesn't have to prove a thing.
Yes, ma'am.
And if the state fails to prove its burden beyond a reasonable doubt of even one part of a charge, the jurors must find Ms. Vallow Daybell not guilty of that charge.
Yes, ma'am.
Okay. Is there anything about conversations or impressions or stories that you've heard from your parents that would make it hard for you to hold the state to its burden of proof?
No, ma'am.
Okay. Is there anything about any conversations you might have had with them, any impressions they had of their caseload that's going to make you're going to hold against Ms. Vallow Daybell?
No, ma'am.
Okay. What about anything about that those conversations, those impressions that you would hold against the state of Idaho?
No, ma'am.
Okay. You understand people deserve to be judged based on only evidence in this courtroom, right?
Yes.
And anything that you might have heard, because we all come into situations with ideas or opinions and even sometimes biases, right? Right?
Yes.
The question is, can the people in that jury box put those things aside and give both sides a clean slate, a fair trial? Does that make sense?
Yes, ma'am.
Is there anything about either your conversations with your parents or things that you have heard in this, in this process that's going to make it difficult for you to do your duty to both sides?
No, ma'am.
Okay. Thank you, ma'am. Now I'm going to ask you all to listen to my conversations with jurors because I'm not going to ask every time, does anybody have a reaction to that? But the idea is we learn from each other, and if there is something like Ms. Blake said, if there's something that triggers, only you know what's going on in your head, and it's too important to Ms. Vallow Daybell and to the people of Idaho that you tell us. We aren't clairvoyant, okay? All right. Juror 1465. Yes, ma'am. I believe I read that your granddaughter is a deputy attorney general?
Yes.
Does she do, and I think she said she prosecuted cases?
She has in Oregon.
Okay, in Oregon. In the state of Idaho, however, is she doing prosecution or is she doing civil?
I honestly don't know.
Okay. And perhaps we can, and I don't remember, and I'm going to ask one of my colleagues to double check if we have her name. What we might do is, at a break, Your Honor, we may want to inquire as to that name, given some other issues on this case, just to be safe. Okay. All right. So we'll circle back on that. But in terms of generally talking to her about her job, have you had conversations about cases that she's prosecuted?
I have heard of cases in Oregon after the fact, whether she lost or won, pretty much. But she doesn't discuss her cases with me.
Okay. Is there anything about those conversations that gives you hesitation about your ability to judge this case?
Not at all.
Okay. Did you get that, ma'am? Okay, I just want to make sure. We have to take turns, and I want to make sure I'm being fair to her. She can't take us both down at the same time. So, all right. Now, ma'am, is there anything about the fact that your granddaughter was once a prosecutor or may remain a prosecutor that's going to cause you to make it easier on the state of Idaho?
No.
Okay. Or anything you're going to hold against or in any way influence your opinion or your evaluation of the evidence with regard to Ms. Vallow Daybell?
No, I will listen with an open mind.
Okay, thank you. Juror 1265, sir. I noticed on your questionnaire you talked about real evidence. You understand that the court is going to give you an instruction on what types of evidence you can consider and the weight you give those, right? Yes. Okay. And that the court is going to provide you all of the instructions on that.
Yes.
All right. If the court's instructions discussed your ability under the law to evaluate circumstantial evidence, okay?
Okay.
And given in sight of your real evidence, that's why I want to follow up on this with you. Let me do this. I believe you have children?
Yes.
Okay. If you walked into the kitchen and you had told all the kids, do not open the cookie jar, do not eat the cookies, they're for dessert, don't touch them.
Okay.
And one of them, no matter how cute they are, is standing there. They got crumbs on the front. They got chocolate around their mouth. They got chocolate in their teeth, and their hands have crumbs on them.
Okay.
Okay? You with me?
Yep.
But they don't say a word. Are you going to be, is your reason and common sense going to lead you to the conclusion that they ate the cookies? And cookies are missing, by the way.
It's going to cause me to ask them probably first what happened to, it looked like you had the cookies, yes.
Right. And so you're going to, on your reason and common sense, you're going to have a belief that they ate those cookies, right?
Yes.
Okay. That's called circumstances, right? And so that is evidence the same way as, say, a fingerprint or DNA.
Okay.
Does that make sense?
Yeah.
Okay. So in your discussion on, and the court is going to give you those instructions that we talked about. He's going to tell you that we have to prove each one of those things beyond a reasonable doubt.
Yes.
Okay. And I keep saying that because that's up the state's burden and we welcome it. That's our job and we're okay with that. And I really want to make sure everybody understands that. Okay. Yeah. But he's going to tell you we have to prove each parts of those definitions beyond a reasonable doubt. But he's not going to tell you how we have to do it.
Yeah.
He's not going to give you a formula. He's not going to say you got to give a certain type of evidence in order to convict somebody.
Right.
Right. In fact, jurors can even, under the instructions, consider convicting somebody based on circumstantial evidence alone.
Okay.
Okay. Given your comments about real evidence, I just want to make sure if the state proved to you beyond a reasonable doubt all parts of a definition, so that your reason and common sense leads you to believe we've proven each of those parts, but the evidence you saw was only circumstantial evidence, but you believed each part.
Yes.
Could you still consider convicting somebody if all you saw was circumstantial evidence?
Yes, and my real evidence was for what was presented in the courtroom, not something that somebody had talked about outside. So that's what I meant by real evidence.
Excellent. Thank you. I just wanted to make sure. I appreciate that.
Yeah.
Did all the jurors, I thought I saw juror 1621 kind of look up when I talked about circumstantial evidence in that conversation. Juror 1621, did you have any thoughts on that? Or what's your let me do it this way. What's your reaction to that conversation?
Could I get the definition of circumstantial?
Well, let's use the cookie jar analogy without getting into definitions of the law because I don't want to do anything that would violate the court's order. But let's say you're in the kitchen and you see children and they've been told stay away from the cookies and then there's crumbs, there's the chocolate on the fingers, there's the chocolate on the mouth, cookies are missing. Those are circumstances. Does that make sense?
Yes.
Okay. Could you, if the state were to prove each part of the definition to you beyond a reasonable doubt, but the state only supplied circumstantial evidence to you, okay? They didn't produce an eyewitness, but they produced circumstances that led your reason and common sense to believe each part had been proven beyond a reasonable doubt. Could you consider convicting somebody with circumstantial evidence?
Yes.
Was there hesitation, or you just...
No hesitation.
Okay. Anyone else have a reaction to that? Okay. Thank you, sir. Back to Juror 1265, sir. I see you're a marriage coach.
Yes.
Is that your profession?
Yes.
Okay. Have you taken any criminal justice courses, psychiatry, psychology courses?
None.
Okay. Have you ever had to be involved in a court suit involved in any of your practice?
None.
Okay. So never got dragged into family court.
No.
Good.
It's a fairly new coaching business.
Oh, cool. Okay. And is that a faith-based coaching practice?
It has faith-based options, but you don't have to have faith to go through it. Yes.
Understood. And so I anticipate, let's talk a little bit about witness credibility, if we could,
Sure.
With regard to that. Jurors are required to evaluate the testimony of people in a courtroom based on their answers, perhaps considering their training, their background. Does that make sense?
Yes.
And it is possible you will hear evidence about a witness's sort of religious beliefs. Now, it is certainly something you can consider in assessing their credibility on whether you believe them or not. But the question becomes, if somebody's religious beliefs were different than your own, or you were to conclude they were strange, or you thought it unusual, is the fact that they had religious beliefs or thoughts or a faith that's different than your own and that you think might be a little odd going to make you automatically disbelieve someone?
No.
Okay. And there are people who have such strong faith that they really just can't assess someone. Is there any way that you have any of those concerns?
Not at all.
Okay. Did anyone else have a reaction to that? Okay. I believe I'm done. One moment. Let me check with my team if I may, Judge.
Yes.
Thanks.
All right, at this time then, the defense may be allowed to conduct their voir dire. Mr. Thomas.
Good afternoon. Just have a few questions. I'm probably not going to be as long-winded as I have been in the past, so because the prosecution and the judge have asked a lot of the questions I'm going to ask. But I do have a couple of follow-ups. Let's see, juror number 1462. You've indicated that that you have blood kind of makes you nauseous and likely to faint, but then you indicated that happened since when you were a kid, right?
It still makes me nauseous, so I tend to avoid it.
Okay. I'm going to be honest with you. There's going to be quite a bit of evidence that you're going to hear about, you're going to see. There's some pretty gruesome things. Is that going to be hard for you to stop? Because we don't want you to come in and be part of the jury and then say, "Gee, man, I can't look at that picture," or "I can't hear that evidence because it's in it, and I'm trying to block it out," or because I think you said something about you just try to, when there's a movie or something, you just try to hide your eyes or whatever. That's not going to be an option for you. You see what I'm saying?
Yeah, that could be a problem.
Yeah. Okay. And while we want you to be on the jury, we want everybody to have their day in court, and we want everybody to be able to serve. Maybe this isn't the right trial for you, right?
Yeah, could be.
Okay.
The last one I did, there was no blood.
Yeah. Based on that, Your Honor, I'm going to ask the court to challenge this juror for cause.
Okay, let me ask a follow-up question or two of my own for this particular juror, 1462. It's, I think, been pretty well explained that nobody's expected to like to see those images. The question is whether you would be able to view them if you needed to. And I'll note there could be some accommodation. For example, if somebody needed to take a break for a moment, we could do that. So I just want to let you know the court can make things as comfortable as possible, but absolutely you need to give your full attention and view that type of evidence if it's presented. So that's what I wanted to clarify in terms of how the process would work. Given that, do you feel like it would just be too uncomfortable for you to maybe remain level-headed and clear thinking if you're exposed to that?
I believe I could remain level-headed. I would be very uncomfortable. I might wish for one of those sacks from the airlines.
Okay. Mr. Thomas, I asked my questions. I'll let you ask any follow-up in the state as well before we make a decision on this issue.
Thank you, Your Honor. And so I know the judge said he's going to be able to make some accommodations, and I'm certainly not speaking for the court or for the judge, but some of this evidence is going to go back into the jury room with you, and you'll be talking about it with the other jurors, and you'll be looking at it, and I want you to be able to face it head on and go, yeah, I'm looking at body parts, and I'm having to focus on that and decide those kinds of things. I mean, that's going to be a reality for you. So I'm asking you honestly, just if you feel like that's not going to be something that you can do, help me out.
Yeah, that would be very, very hard. Yeah, that might be something I cannot do.
Okay. I would renew my challenge, Judge.
Okay. Any response from the state?
Yes, Your Honor. So I know we've spent a lot of time on this issue with you, and I think specifically in your questionnaire you talked about blood, and you and I talked about seeing blood in person versus photos or a movie.
Yeah.
And so, and the judge talked about some accommodations. Mm-hmm. So if you needed to take a break. So I think the question is, could you view the evidence and still give that evidence the weight you believe it's due while still listening to the other evidence and giving that evidence the weight it's due? Do you feel that you could equally or weigh the evidence to the extent you thought that evidence needed to be weighed and render a fair and impartial verdict?
Yes, I could.
Thank you. Judge, we would object.
All right. The court's considered the challenge here. I'll note we've gone through a lot of jurors in this process, and this one in particular, I think, has been able to express the greatest concern probably of anyone we've talked to when it comes to that nature of evidence. Some people are more susceptible to perhaps being traumatized by that type of evidence than others, and I do think that with some of her questions it's raised enough of a concern for the court that it would likely result in an undue hardship for this particular juror to be able to sit on this case in light of what the parties are representing the evidence may be. So for that reason, I am going to sustain the challenge on Juror 1462 and consider that an excuse for hardship. So Juror 1462, thank you so much for your service. I'm glad you're such a kind-hearted person, and you can be excused from your service at this time. And as I mentioned to other jurors, if you wish to speak to others about your service here, you can do that, but respect the privacy and feelings of your fellow jurors, and if somebody persists in trying to talk to you, please report that to the court. All right, thank you. You can continue, Mr. Thomas.
Thank you, Your Honor. Juror number 1621. You have indicated on your questionnaire that you had heard about the case, and then it was basically on KTVB 10 p.m. news.
Yes.
Can you expand a little bit on what you've heard about the case?
I usually watch the news for the weather, but I've seen clips.
And Your Honor, I apologize, but I think we're getting into what the court wanted to take up in individual voir dire.
I agree. Let's save that for an individual voir dire, Mr. Thomas. Thank you.
I do have a couple other questions for you, though, okay? So we'll talk about that in a little bit. So you indicate that that this may be a hardship for you, the length of the trial being 8 weeks long. You have a full-time job, is that correct?
Correct.
Do you support a family?
I do not.
Okay, so it's just you?
I live with my family, my parents.
Okay, all right. And you indicated, I believe it said that you rent, so you pay your parents' rent?
Correct.
Okay. And not having to be able to pay, I'm assuming are you going to work while you're on jury duty?
No.
Okay. So having that 2-month period of where you wouldn't be able to pay rent or basically have any income, is that going to be a hardship for you?
No.
No? Okay. And have you talked to are you working right now?
Yes.
Have you talked to your employer about that?
My direct supervisor, yes.
Okay. And they're okay with you being here for 8 weeks?
Yes.
Okay. All right. Juror number 1628. Kind of has a similar line of questioning. You have a 3-year-old at home, is that right?
2.
A 2-year-old.
2
Or
3-year-olds.
2 3-year-olds. Twins?
Yes, sir.
That's awesome. My dad's a twin. That's pretty cool. Boy and a girl, or just 2 girls or boys?
Yes, sir. Boy and a girl.
Wow. That is amazing. I'm sure it's really hard, but it's pretty cool having an uncle and my father the same. And then you also indicated that you had some work obligations. Is that right?
Yes, sir.
Is that going to be a hardship for you? I mean, we don't necessarily want you to put yourself in a position where it's going to be a struggle on your family or on. We all have to work. I mean, we all have to make money. We understand that, and so is that going to be a hardship for you?
It's not ideal, but my employer is willing to work with me on it.
Okay, good. And is it a situation where you're going to be able to be compensated for the next 8 weeks, or is that something that you'll have to take vacation or uncompensated time?
My company offers paid jury time.
Okay.
To an extent.
Oh, but not for the full 8 weeks?
We would take it up with HR to ask for the extension.
Okay.
That's what my supervisor has said.
Okay. If you get selected?
Yes.
Okay. All right. You're currently in the Army, is that right?
Formerly.
Former. And it looks like you served in Germany?
Yes, sir.
I was born in Germany. Landstuhl Air Force Base. Thank you for your service.
Thank you.
Okay, I have no other questions for you. Thank you so much. Let's now turn to 1265. So we talked a little bit, or the prosecutor talked a little bit about your questionnaire. And your questionnaire, you said that if presented with real evidence, you would form a new opinion that was not media biased, right?
Yes.
And so,
Your Honor, again, I worry that we're headed down, with the mention of media, I worry that we're headed into what the court has indicated will take up an individual voir dire.
Well, we're fine for now. Just don't elicit any specific comments about the exposure, and I'll ask the juror to do the same. So just answer in general terms, please.
sure. And this, I'll just bring up that the state brought this specific question up already.
I understand. So you can continue.
All right. So what sort of real evidence would you need to be presented with?
The evidence that was brought forth in this trial.
Okay. So would you need the defendant to bring some evidence?
No.
No?
No.
Okay. But you've indicated that you've already made some sort of an opinion. You've already had an opinion about Lori Vallow, right?
Correct, yes.
Okay.
I mean, yeah, to a certain extent, sure.
Yeah.
I don't know much about this case other than the years ago I work at home, like what I used to do was in-home sales for remodeling, and people would have media on, like just, on their TVs or whatever, and so occasionally people would be talking about it when it was in the news, and my only opinion I ever formed was, I think someone was maybe referring to it in a negative light, and I just said, yeah, that it, circumstantially, didn't look great, but that was the only opinion I ever formed.
Didn't look good.
Didn't look good.
Right. Okay. Okay, thanks. 1465. How are you today? Good. So, you, how do I put this? You're at an age where you can be excused based on your age. Is that something that you want to do? Do you want to be on the jury?
I'm happy to serve.
Happy to serve. Okay, good. Right? Okay. So it's not going to be a hardship for you to be here? Okay. All right. Good. I just want to give you that out. $15.35. How are you doing? Good. So I looked through your questionnaire, and it didn't look like you had any exposure as to who Ms. Daybell is, correct?
Correct.
So you've never heard of her before you came into jury duty?
I never heard. I just moved here a year ago.
Oh, really? From where?
What's that?
From where?
Oh, California.
Oh, okay. Where in California?
Los Angeles.
Okay. All right. Well, welcome. That's all I have, Judge.
All right. Thank you, Mr. Thomas. All right, counsel, we will next go into individual voir dire. Before we do that, I'd like you to look at the questionnaires again for jurors 1465, 1535, 1628, and 1631. As I review those, I don't know that there's a need for individual voir dire for those jurors, but if there is, please let me know what it is, so I'll give you a moment to look at those 4 questionnaires again. Yes. 1465, 1535, 1628, 1631.
And Judge, if we're talking about for individual voir dire, and especially with the media, I think the only one the state would wonder is 1621, just based on one comment on the questionnaire, maybe just a little bit of follow-up. And it's just talking about news sources watched, if the court's wondering. We just wanted to clarify a few things based on that.
Okay, yeah, the four I identified, I thought didn't express anything that required individual voir dire. So you think 1621 fits in that as well?
I think that does. Just some brief follow-up.
I guess I'm confused now. So you do or do not want individual voir dire on 1621?
Yes, we did think that one. We think the other numbers read by the court would not require individual voir dire.
Okay.
Given the court's admonishment to me about going into other things, I would just ask to be able to individually voir dire everybody on the panel about the media.
Well, I think I can help make that a little more efficient by asking some general questions to those jurors. They've all indicated, the four I read at least, no exposure at all, and I think they can just be asked whether that still continues to be the case. So give me a moment. So 1265 and 1535 both have expressed, I'm sorry, 1535 is not on there, so I guess it's just 1265 certainly would require individual voir dire, know something about the case. The others then, let me just ask you as a group, in your questionnaires, you all indicated essentially you just didn't know anything about the case. So if you put that in your questionnaire, other than what was advised of you in court when you came in to fill out your questionnaires and today, other than that, is it still correct that you don't have any information about this case? Okay, let me just go down the list. I probably have somewhat lost track now, but 1265, I wouldn't ask you because you've indicated you do, and we'll talk to you about that. 1465, is that correct? That you don't know anything about this case and didn't? So that's correct?
That's correct.
Okay.
Sorry.
All right. 1535, is that correct? I think 1621 is, I had a question. Okay, 1621 we would talk to individually, and so then for juror 1628, is it correct you just didn't know anything about this case until you came for jury duty? Okay, and I'll ask finally for 1631, is it also correct you didn't know anything about the case until you reported for jury duty? Okay. Well, counsel, I don't see a need for individual voir dire on them unless there are other topics, and if you want to have any final probing question on that, Mr. Thomas or the state, I'll allow it because I don't see a risk of going into any detail here, and we'll certainly reserve the other two for individual voir dire. So do you have any follow-up questions, Mr.
I do.
Thomas? Okay.
1628, you indicate that you have two 2-year-olds, twins. Do you have any social media that you normally go on?
I'm on Instagram and Facebook.
Instagram and Facebook. And you've never seen anything scroll by about this case?
No, sir.
You've never seen a YouTube video on it?
No, sir.
Never saw anything come up on the news?
I don't watch the news.
Okay. Nothing further.
Okay. Does the state have any follow-up, voir dire, before we go to individual?
No, Your Honor.
Okay. So give me just a moment again to get organized here. All right, we'll be talking individually to jurors 1265 and 1621. Let me go through the others that I've got here and ask then, on juror 1465, does the state pass that juror for cause?
Yes, Your Honor.
Does the defense? Okay, juror 1465 has been passed for cause, so we won't do individual voir dire with them. Juror number 1535, does the state pass that juror for cause?
Yes.
Does the defense as well?
Yes, Your Honor.
Okay, juror 1535 has been passed for cause. Juror 1628, does the state pass that juror for cause?
Yes, Your Honor.
Does the defense pass that juror for cause?
Yes, Your Honor.
All right, juror 1628 is passed for cause. And juror 1631, does the state pass that juror for cause?
Yes, Your Honor.
Does the defense pass juror 1631 for cause?
Yes, Your Honor.
Okay, so we will have all of those jurors, we'll have everybody except juror number 1265 retire to the jury room, and we will individually conduct questions with juror 1265, and then we'll come back to 1621 after that. If all would please rise for the jury. Thank you. Please be seated. All right, juror 1265, first of all, I want to let you know you're not in trouble for being here as the only juror sitting there right now.
Just telling the truth. So
Sure. Hey, everybody is entitled to watch the news as much as they want, follow whatever stories they want. There's absolutely nothing wrong with that. Many people do. This case has garnered a lot of media attention and pretrial publicity, and so we need to inquire as to whether or not that's affected somebody in such a way that they should not be serving in this case. So a few preliminary questions I'll have for you. First, before you came in and reported for jury duty last week to get your questionnaire, were you at all aware of what charges had been filed in this case against the defendant, either here or anywhere else?
no, I completely forgot about this case.
Okay. Thinking back now, well, that answers that question. The next question I would have then is, at any time in the past, do you recall watching any kind of a news program or special dedicated to this case, like a 48 Hours or Dateline or some documentary or made-for-TV movie or anything like that?
No.
All right, that'll conclude my questions for this particular juror then. Does the state have any individual voir dire for juror 1265?
Briefly, Your
Juror 1265. Okay. You understand that anyone brought in before the court has a presumption of innocence, right?
Yes.
And that the jurors in any case have to only judge the evidence that is presented from the witness stand or allowed in court by Judge Boyce in this particular case.
Yes.
Okay. Is there anything about what you saw on the news or you saw other places that you're going to be thinking about while somebody's testifying on that stand?
Nothing at all.
Is there anything about that you're going to be thinking about when you're trying to decide whether the state proved its case beyond a reasonable doubt?
No, the defendant deserves a fair trial. I 100% believe that.
Okay. And so there were some remarks in your questionnaire about, seeming suspicious or along those lines. Is that an opinion that would affect your assessment of the evidence in this case?
No, I can be 100% objective in this case.
Okay, because you recognize, I'm just being really blunt, you recognize how important it is to both sides.
100%.
Okay, and anything that you could think of, you're not going to be doing a compare, like I saw this here, what does it look like in courtroom? There's no compare contrast?
No.
Okay, thank you.
All right, thank you, Ms. Smith. Mr. Thomas, you can inquire.
Thank you, Your Honor. On your questionnaire, you indicated, the question was, what have you heard or what do you know about the defendant, Lori Daybell? And you said, dead spouse, comma, children found dead, comma, on the run. So what did you mean by dead spouse?
I think I remember something about, it was, I said that my details are foggy on that. That's what I was going off of what I think I remember. And it was something about a spouse no longer being there and missing children. And then the last I remember seeing about the case at all was that the defendant was found in another place. I don't remember specifically even where that was.
So our problem is that you have things in your mind that may not be percolating up to the top. But as we put on 200 witnesses, those memories are going to come flooding back, and you're going to hear things that maybe are consistent, some are inconsistent, and so you're going to have to weave this whole thing. So when I'm asking about the dead spouse, which dead spouse? Whose dead spouse? Do you know?
I do not remember.
Okay. Children found dead. What about that? What do you remember about that?
I don't have a lot of memory on that. I just remember hearing that children had passed away.
Whose children?
I believe what I remember was the defendant's.
Okay. And how many kids were there? Do you know?
I don't remember. 2 or 3.
All right. And you're not sure if it was the defendant's dead spouse or somebody else's dead spouse?
I am not 100% on that.
Okay. On the run, what was that about?
That might have been commentary at the time from maybe a person that was around me. So I was just answering what came to mind when I thought of it. That children were missing, and that the defendant they had been looking for the defendant, I think.
Okay. Anything about the kids? Anything else about the kids?
No.
That you remember?
Not at all.
Just that they were dead.
Yeah, I remember them being missing, and I remember someone saying that they had been found dead.
Okay. Do you remember where they were found dead?
No, I do not.
What kind of social media do you follow?
I'm on all forms.
All forms?
Yes.
Facebook?
Yep.
Do you get on YouTube?
Yep.
Instagram?
Yep.
TikTok?
Yes.
And none of those things had any kind of a feed where you heard anything about the defendant?
I have completely forgot about this case until Monday when he said the name.
And you don't remember where she ran off to?
No.
Okay. Well, last week when you filled out
I might have said Hawaii. That state is coming to mind. I don't know.
So last week you remembered it was Hawaii, and then I just asked you where it was, and now you don't remember, but now you're saying it might be Hawaii.
Yeah. As I said, I don't have a lot of memory of this case. And I was never intently ever watching it. It was background and commentary from people that I was around in their homes.
Uh-huh. And you indicate, it says, has any of your possible exposure to the news reports dramatized depictions or publicity around the case caused you to form an opinion about Lori Daybell, and you said yes. I just remember thinking, why would she be in Hawaii if her kids are missing?
Sure.
Do you remember that?
Sure.
Okay. Can you expound on that a little bit?
I think that's just what that didn't look good if she was in Hawaii when her kids were missing. That's what I remember thinking.
Yeah. And that's what you formed an opinion like, hey, she probably killed these kids.
I did not form that opinion. I just remember that didn't look good.
So that was the opinion that didn't look good.
Correct.
Okay. And then the next question is, you indicated if you were presented with real evidence, you'd form a new opinion, not media biased.
Correct.
Okay. But you're admitting that you have been biased by the media?
I'm admitting that, yes, I had an opinion when I was in front of the media that had been played, and then, but I know that that's just what was played there, that none of that's real. I am not supposed to take any of that into account. I am only supposed to take into account what I hear and be completely honest with you. So that's what I'm doing.
Right. But you take with you all of your experiences of life, and some of those experiences of life are hearing other people talk about this case, right?
Sure.
And there were a lot of people that were talking about the case, right?
Sure.
Okay. Did you have any exposure before you came into jury duty, knowing from either the media or one of the social medias or one of the TV stations that, hey, this is a big case coming up, and man, your number got pulled?
I completely forgot about this case.
Completely forgot.
100%.
Okay. Your Honor, based on his answers today, I'm going to challenge this this juror for cause, indicating that he did indicate that he had a media bias, and that when some real evidence came in, he would form a new opinion, but he was biased by the media.
All right, what's the response from the state?
I think the juror's answer speaks for itself. He recognizes that whatever he saw out in the world or the internet or what somebody said wasn't real. And I think his question, in light of his explanations both to the state and to defense counsel, shows his absolute ability to put aside whatever things he might have heard and judge the case on what the court decides is real evidence admissible in this courtroom. Nothing about his answers indicate an inability to follow the court's instruction. Nothing about his answers suggests he can't be fair and impartial to both sides.
All right, thank you, Ms. Smith. Court's considered the challenge on Juror 1265 for bias. The concerns raised here, I find somewhat troubling. The response on page 11, question 2, reference to a dead spouse, which raises a concern for me. There's also the concerns raised about prior exposure to facts of the case, about forming a new opinion. The concern I also have is the juror indicating that he had forgotten things about the case, but is perhaps being reminded about things about the case. And I think it becomes unclear then whether or not, as evidence is presented, more memories may surface that may conflict with what's being seen in actual evidence. Under Idaho Code 19-2019-2, I have to consider whether or not there's some inference that a juror may not be able to act with what they call entire impartiality. And so, exercising caution here, Juror 1265 will be excused for cause. Again, Juror 1265, we appreciate your candor and your responses. We're just trying to get the best jury possible in this case, and I appreciate your service coming in today, as well as your time spent answering the questionnaire. And with that and the admonishment I've previously given jurors when they've left about communications, you can be excused. Thank you.
And Judge, before the next juror is brought in, can we approach?
Yes.
will have to unmute when they're done with the sidebar. I try not to make judgment calls. I leave that in the room. When they go back, the judge comes back, we'll unmute it. But if I grab one of you guys, go first. I'll ask him to make sure. Judge, just a moment. May we unmute the live stream?
Okay, thank you.
The live stream is going again, Judge.
All right, thank you. At this time, I'll just have all of the remaining jurors brought back in as a group. Yes. They're coming in with the rest of the group, 1621. So, no, well, I'll just address them now. I don't need to talk to them individually. Okay, thank you. Okay, thank you. Please be seated. We're back on the record now on CR 2221-1624. We conducted individual voir dire of the jurors in this case. We were going to do that on Juror 1621. Upon further review of the questionnaire and in discussion with counsel in a brief sidebar, the state believes they've identified what would be an appropriate strike for cause for bias as to Juror 1621. Is that correct, Ms. Blake?
That is correct, Your Honor.
All right. Does the defense join in the challenge for bias as to Juror 1621? All right. The court did consider the responses in the questionnaire, and also looking at the standard I apply, I do find that there's a risk here that this particular juror may not be able to act with entire impartiality, and for those reasons, I'll find that the cause challenge of 1621 is sustained and Juror 1621 will be excused. So for you, Juror 1621, I'll just have you remain seated with the other jurors for a moment. You are excused from the case, and as you leave today, again, you're entitled to talk to anyone you want to about your jury service, but respect the feelings and privacy of your fellow jurors. If somebody persists in talking to you and you don't want to talk to them, then please report that to the court. For the other remaining jurors at this time, and just to make sure the record's clear, everyone but 1621, if you'd raise your red card at this time. So jurors 1, 4, 6, 5, 1, 5, 3, 5, 1, 6, 2, 8, and 1, 6, 3, 1. You have been passed for cause at this time, which means that you will be required to report again to court for the peremptory challenges, which will be exercised most likely later this week, and perhaps as soon as tomorrow. We'll have the final scheduling worked out as we go. You're instructed to contact the jury commissioner, or they will contact you, and you'll be given instructions as to when you are specifically required to return. We'll provide you with a business card for the jury commissioner so you have their contact information. I'll advise you that while you're waiting to be recalled to court, if you're approached, questioned, followed, or in any other way bothered, please report this to the court immediately upon your return. And also, you'll be required to again fill out that affirmation that between now and that time You do not conduct any sort of investigation in the case. Don't look into the case. I realize the case is in the media a lot right now. If you see it come up on your device, on the computer, on the news, please don't watch anything about it so that you can maintain your impartiality that we've worked so hard to ensure you have getting to this point. After you return then, we'll go through the peremptories and you'll be advised at that time whether or not you remain to serve in the case. So I appreciate the service of everyone that's here today, and that will conclude the voir dire of this group of jurors. Is there anything else we need to bring up from the state before we release these jurors?
No, Your Honor. Thank you.
Anything else from the defense?
No, Your Honor.
Okay, thank you, counsel. So all please rise for the jury. All right, let's take a brief break then, and we'll get the next group lined up. Does everybody want to agree on where we're at this point and make sure we're all tracking the number here? Because I think we're getting close to the number 42. Yeah. 39.
Yes.
All right, let's take a recess then, and we'll start up with another group of jurors and see where we land at that time. So I'll work with the marshals or bailiffs here to see how long it'll take to get them lined up and ready to go, and try to take a fairly brief recess here if possible.
And we'll compare notes to see how many we can agree on.
Okay, if you'll go through that, that's been very helpful, so do take your time to do that, and once you're ready and the jurors are ready, then we'll come back to the bench.
Judge Ravello, we're going to be taking a brief recess. Do you have an ETA on when the jurors can be?
All right, if we could have the next panel of jurors brought in, please.
Judge, would you like the live stream resumed?
Yes.
Did you see it? Yeah.
All right, please. Panel's all present, Your Honor.
Okay, thank you. Please be seated. We are back on the record on case CR 22-21-1624, State versus Lori Vallow. We are conducting voir dire of individual groups of jurors. This is group number 3 for the day, and the jurors have been brought to the courtroom. The court notes that the prosecution is here. The defense also is present in court along with the defendant. And ladies and gentlemen of the jury, you've been returned here after completing your questionnaires for the court to determine whether or not you'll continue in the case or whether there's a challenge to your service based on any bias or hardship. So upon review of the questionnaires, we have the court has conferred with counsel and determined that certain of the jurors today should be excused for cause or for hardship. I'll first indicate that your time you've committed here is certainly welcome, and you've completed your jury service if that's the case. Also, I would advise you that upon being excused today, if don't feel offended or that somehow your integrity or honesty was challenged here. It's simply a matter of us trying to go through the process to get the most fair and impartial jury possible in this case, and that was the purpose of those questionnaires, which have been very helpful. We appreciate your candor and your responses. If you are excused, I'll give you another instruction as you leave. So at this time, the court will go through the list. We'll take a roll call in a moment and note a couple of jurors failed to appear, so we'll address that when we do the formal roll call. The jurors I'll address next, based on agreements between the parties, would be starting with juror red card number 15. That particular juror had expressed a concern about a hardship. The parties reviewed that and agreed that that juror should be excused based on a hardship. Does the state agree that juror 15 can be excused for that reason?
Yes, Your Honor.
Does the defense agree?
Yes.
Okay, juror 15 will be excused due to hardship. The next juror we'll look at is juror number 23. On juror number 23, the parties have reviewed the responses to the questionnaire, and it appears this juror was exposed to some pretrial information about the case that the parties believe would result in a possibility of bias in the case. So does the state move to challenge juror 23 based on those responses for bias?
Yes, Your Honor.
Does the defense concur in the challenge?
Yes.
Okay, the court has reviewed the questionnaire and also consider that juror number 23 should be excused based on bias. The next one we'll take up is juror number 184. For juror number 184, there was an indication that could I have a brief sidebar with counsel as it relates to 184, please? Okay, thank you. Thanks for clarifying, counsel. So as to juror 184, there is no challenge at this time to take up. The next one we'll call up then is juror number 250. The parties went through the questionnaire of juror 250 and found indications that they believe there may be a bias represented based on the responses. The courts reviewed that questionnaire as well. Does the state raise a challenge on juror 250 for the cause of bias?
Yes, Your Honor.
Does the defense concur in that challenge?
Yes.
Very well. Juror number 250 will be excused based on that reason. The next one we'll take up is juror number 274. On juror number 274's questionnaire also, the parties indicated a concern about potential bias in the case based on responses and pretrial publicity and exposure to the case. Does the state challenge juror number 274 for possible bias?
Yes, Your Honor.
Does the defense concur in that challenge?
Yes.
Very well. Juror number 274 will be excused as well for bias. Juror number 326. Juror number 326 indicated that while they thought they could serve here, there was still some concern the parties raised about whether or not this would create a hardship based on their personal circumstances. Does the state believe juror 326 should be excused due to hardship?
Yes, Your Honor.
Does the defense agree with that?
Yes.
Very well. The court's reviewed that questionnaire also and find good cause to find a hardship excuse requiring the excusal of juror 326. And then finally, juror number 389. After review of the responses in the questionnaire, the parties raised a concern regarding a possible bias in the case. And this juror has also seen information about the case indicated in those responses. Does the state believe juror 389 should be excused based on bias?
Yes, Your Honor.
Does the defense join in the challenge?
Yes.
Okay. The court concurs also that juror 389 would be excused based on bias. So, ladies and gentlemen of the jury, if I just called your juror number there, going through those questionnaires, jurors number 15, 23, 250, 274, 326, and 389. For each of you again, thank you so much for your time and service and reporting back here, for completing your duties as jurors in this case. If anybody wishes to talk to you about your jury service, you're free to do that. However, please respect the privacy and feelings of your fellow jurors and only discuss your own personal perceptions or feelings about your service here. If somebody wants to talk to you and you don't want to talk to them and they persist over your objections, then please report that to the court. And with that, you do have the sincere thanks of both the court and the counsel for both parties here in your service today, and you can be excused. So I'll have you go with the bailiffs at this time, and then we'll talk to the remaining jurors. All right, next I'd like to discuss an issue with juror number 116. So that's the gentleman, I'm sorry, I won't refer to you. That's just juror 116 in the top right there. We have requested that you complete these juror affirmations about whether or not you've refrained from looking into the case at all, and I was advised that you did not sign the affirmation. I'd like to question you regarding that. Did you intentionally decline to sign that for some reason?
I did, in that section D there, that paragraph D that talks about if someone else has talked to you about it. My wife is a crime junkie, so trying to get away from her when we both work from home is difficult, and trying to tell her to not talk about anything has been difficult for the last week.
Okay, and I understand the circumstance. You are not the first juror that's had this situation arise, and this is in particular why we have the juror affirmation. So first, I commend you on your honesty. It's exactly what we want people to do. Let me ask you a couple of follow-up questions. Were these conversations relating to this case since you came in and filled out your questionnaire?
Yes, sir.
All right. Did she discuss with you some facts and knowledge she had about the case that you didn't previously know?
No, but she's looking at the news and telling me how many jurors they selected on Monday. She's like, stop talking to me about this.
Okay.
So yeah, she's brought things to my attention, unfortunately. when I've asked her not to.
Do you think that situation will persist if you're here for 8 weeks serving on this jury?
If I'm allowed to go home, yes.
Well, I'll allow you to go home. And based on your answers, I do think that you should probably be disqualified from service for that situation. And again, it's not a personal thing. It's just us getting the most fair jury we can to go through the entire trial. Does the state have any objection to excusing Juror 116?
Not based on his answers, Your Honor.
Okay. Does the defense have any objection to him being excused?
No objection.
All right. Well, Juror 116, thank you for being honest and for reporting to the court what occurred. You can be excused with the same admonishment about communications I just told the other jurors, and thank you. Did I give you the rest of the admonishments? Oh, okay. All right, at this time the court will commence with the voir dire of this group. Ladies and gentlemen, thank you for returning. You've all been recalled as prospective jurors in this case. I'll briefly reintroduce the case to you. I'm Judge Stephen W. Boyce from Fremont County, and I'm in charge of the courtroom in this trial. Here assisting today is a court clerk who will be administering oaths. The court reporter will be taking a stenographic record. The bailiffs are assisting with the jury, and my staff attorney will be assisting with legal issues that may arise. Each one of you is qualified to serve as a juror of this court, and we've reviewed now your questionnaires, so we will be following up with additional questions. At this time then, to keep the record clear, I would request that the court clerk conduct a roll call of those remaining jurors. So as your number is called, please hold that number up and indicate here if you're present.
Juror 1793. Juror 55. Juror 64. Juror 184. Juror 228. Juror 290.
Thank you. At this time, to assist you in understanding and participating in the jury selection process, I'll briefly reintroduce you to the parties and their lawyers at this time and summarize what this case is about. The state has brought this case, the state of Idaho. I'll sometimes refer to them as the prosecution. The state is represented at this trial by Lindsay Blake, who's the prosecutor for Fremont County, and by Rob Wood, who is the prosecutor for Madison County, and by specially appointed prosecutor Rachel Smith. The defendant in this case is Lori Vallow, and she's here represented by her attorneys Jim Archibald and by John Thomas. Thank you, counsel. This case is a criminal matter, which means that the defendant is charged by the state of Idaho with a violation of the law. I previously read to you a summary of the charges in the indictment. With regard to the defendant, the state of Idaho alleges that Lori Vallow Daybell committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. And count 7, grand theft. The defendant has pled not guilty to all the charges. Please remember, this is simply a description of the charges, and it is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If, after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next discuss your duty as jurors. Your duty is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including through the use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I would ask the jurors to please stand and raise your right hand, and the clerk will administer the oath.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God?
Thank you. You can be seated. The record should reflect all the jurors took the oath. I'll next ask of the parties, will the state stipulate these jurors have been properly called and paneled and are properly seated?
Yes, Your Honor.
Thank you. Does the defense also stipulate the jurors